Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Hello. Welcome back, guys. Welcome back to J is for Justice. My name is Jay. I am your host. We are convening today, if you will, for a hearing for Stephan Stearns. We have Sarah, one of our members, is in the courtroom. Welcome in, everybody. Happy Wednesday. I hope you're all doing well today. What's up, big girl? What's up? So Stephan Stearns looks a little bit different. He had a hearing yesterday. They're trying to get some evidence suppressed. Hey, jammers. Hey, Betsy. Hey, Garden. Jay, you have such a beautiful voice. Thank you. I appreciate that. PJ, Linda Lou, Yoga. Am I refreshed? A little. Angie B, Robat. Big Girl and Nash, Sin, Sherry Baby, Spitfire, good to see you, Buddha, Stephanie, Tabby. I always sing Sherry Baby, Lucy. Good to see you guys, AJ. Thanks for joining me today. You could be watching this hearing anywhere else, but you're here. Thank you, Chris, for being here, and Summer Girl, Mad Dog, Katie Baby, Gina, good to see you, the other Brooke, Clover, Alyssa, Jackie, Miss Nightbot, and the lovely Diana. If I missed anybody, welcome into the stream. We're going to watch this quick clip from yesterday.
Good afternoon. Thanks for joining us. I'm Bridget Ellison. Today, Stephan Stearns, the man accused of killing Maddie Soto, is seeking to delay a court hearing regarding evidence found on his cell phone. And Stearns is facing the death penalty if convicted of killing Soto, the 13-year-old Osceola County girl whose body was found in a wooded area last year. Stearns has pleaded not guilty. Investigative reporter Mike DeForest has followed every development in this case since the beginning and joins us live from Osceola County's courthouse now. And his attorneys are saying they have confidential information, Mike.
Hey, Chris P.
Confidential information. That phrase was uttered several times in the courtroom today. It's a somewhat unusual situation. Let's take a step back. Tomorrow, a hearing is scheduled in this case to discuss evidence. Stephan Stearns' defense attorney asked for tomorrow's hearing, but then in the last few weeks, they've said, hey, wait a minute, we need to postpone tomorrow's hearing because we've just come into confidential information. And they say that confidential information is preventing them from presenting the type of evidence they want to tomorrow. So they asked the judge for a postponement. Let's take a look at some video from the courtroom today. You can see Stephan Stearns entering the courtroom. Here's the thing about that confidential information.
There he is.
Room today, you could see Stephan Stearns entering the courtroom. Here's the thing about that.
He had to look over at those cameras, didn't he? So yesterday they had this hearing because his lawyers were like, we have confidential information. Well, they went in front of the judge and the judge was like, you want me to delay this hearing tomorrow because you have confidential information that you can't tell me? So it was denied. And that's why we're having the hearing today.
Confidential information. His attorneys would not disclose in court today what that confidential information might be. They will only say that they need to look into it further as they try to defend Stephan Stearns.
And I was wondering if this confidential information had anything to do with any other pedos. Like what kind of confidential information could they possibly have?
Against these charges of murdering and raping 13-year-old Madeline Soto. At one point, Stephan Stearns' attorney told the judge, we cannot even tell you what this confidential information is behind closed doors.
They told the judge they cannot even tell the judge the information behind closed doors. What is that supposed to mean? They can't tell the judge even?
Meanwhile, prosecutors say they are all ready for tomorrow's big evidentiary hearing. They have witnesses lined up. They're ready to go. They want this to happen. And so the judge had to decide, do we postpone tomorrow? Well, the judge ultimately found out that since the defense is not telling us what this confidential information might be, I have nothing to go by to cancel tomorrow's hearing. And so tomorrow's hearing will stay on. Back live here. Tomorrow's hearing will happen at 2 o'clock. It's a 3-hour hearing.
3 hours.
Is to
Get
discuss
comfy.
information and evidence found on Stephan Stearns' cell phone. Allegedly.
Dude, it's something about what was on his phone. Stream ended. What? No, it didn't. So, I don't know. What do you mean ended? Am I live or not? Maybe it involves judges? Am I still live? Why is the stream ending? I see 316 here. Okay. Okay, absolutely no electronic devices are to be on in the courtroom. I just got pictures. Hold on. Let me save these. Wow, Sarah, you're great. I don't know if she's listening. I don't think she is. Sarah Luna, our girl, is there. She's got a slideshow of images for us. I don't know if Stearns is going to be there because this says here Madeline Soto's accused killer due in court. Oh, now it says his killer. It said his lawyers earlier. In the title, it says lawyers. But they changed that picture. She said, Stearns hasn't arrived from the jail yet. I'm sitting in the courtroom alone with all these attorneys talking and some inmates. Awkward. Channel 13 Spectrum is asking to go live. They're asking the judge. So let me send these photos over and you guys can see what the courthouse looks like. And
for making it happen. I want to say thank you for making it happen. Thank you.
Thank you, Misty Blue. When ads start, it kicks me right out. That is so weird. It must be YouTube glitch. Is it happening with everybody with the ads? Hey, Petty, it's today. It's in about 15 minutes it starts.
Making it happen. I want to say thank you.
15 minutes.
Thank you.
I want to show you guys these photos she sent. All right, here's the outside of the courthouse here. Osceola County Courthouse. Please turn off all electronic devices and absolutely no communication with inmates. This is on the outside of the door. Hey, everybody that's just joining. Hey, Sin. Hey, Betsy. Hey, Global. Hi, Snazzy. Keith Karsten, courtroom 4F. Electronic recording equipment in use. And then on the docket, we see Stearns, Stephen Michael right there for 2 p.m. on the docket. Thank you so much, Sarah. I know she probably can't hear me right now, but I do appreciate her being there and giving us updates. Hi, Nicole. Hey, Tabby. So what do you guys think about the confidential information that he couldn't even tell? They couldn't even tell the judge. I think that's pretty wild. But defense attorney, I mean, I don't know what to think of it, honestly. Hey, Frenchie mom. Snazzy, thank you. She said, I'm so glad you're covering this. People like this need to be revealed so others are more aware these creeps are among us. Do you remember we reported on Maddie Soto's teacher that was arrested for the child sex crimes or whatever? Well, he pled guilty. Hi, Cole. It's good to see you. He pled guilty. Maddie Soto's the middle school teacher there. Hi, Georgia dog. I think it involves high-profile people and possibly Jen's involvement. But why couldn't they tell the judge? If you can't tell the judge, who can you tell? He was mad. Yeah, he was Maddie's music teacher. That's right. He was in that photo. What's up, Danny? Hey, Crimes. Hi, Avi. Hey, Crimson Moon. Could it be a stall tactic? But, like, that's kind of a game to play with a judge. Like, to go in front of the judge and be like, we can't even tell you. Seems kind of ludicrous. It's weird they use the word confidential because of benefit of high-profile people. It wouldn't be confidential. Well, Tabby, they said they couldn't even tell the judge behind closed doors. I think they cut his hair. And he didn't get a style. He just got a buzz cut. He looks thin. I don't know if he looks quite as thin as he told his mama he did. I've lost a lot of weight. My cheekbones are sunken in.
The man accused.
Let's look at him again.
He joins us live from Stearns has pleaded.
Gus, need to preventing Stearns entering the courtroom.
Who's he nodding at?
Let's take a look at some video from the courtroom today. You could see Stephan Stearns entering the courtroom. Here's the thing about that confidential.
Ooh, he makes me want to throw up. Oh, those calls, Yoga Mom? I know. Hey, Roberta. Yeah, I think that's weird too, Tabby. Like, who can they tell if they can't tell the judge?
Today you could see.
Well, they said they wanted more time to investigate the information, I think is what they were asking for. And he was like, well, if you can't tell me what it is, I can't give you more time. I'm sorry.
Stephan Stearns entering the courtroom. Here's the thing about that.
That just creeps me out right there. Hi, Sarah. Sarah's in chat, guys. Everybody give Sarah your love. Hey, guys, I can hear for a minute, just waiting on Stearns to arrive. So he's definitely coming, Sarah. He's definitely coming. Hey, Kels. What other info is there? I don't know, but it was pertaining to wanting to delay this hearing here. Wanting to delay this hearing here because this hearing is about things on his cell phone. This is about him wanting to suppress things from his cell phone. They said he's on his way now from the jail. Wow, Sarah. Because earlier it just said the lawyers. Ugh. You're going to have to call in and let us know that feeling in the room. Misty Blue, YouTube is acting up today when ads start. It kicks me right out. Thank you for your super chat. I hope that stops happening. She's going to be in the same room with this guy. And look at there's the jury box. I think. There's a lot of spectators, she says. It is eerie. Well, thank you. Thank you for giving us the deeds. I appreciate you. I'm hoping it has something to do with him and other adults rather than all of them with Maddie. Well, that's what I'm thinking, that it might have to do with maybe something else. Maybe something else that they've uncovered or... Island Thrifts. I knew you wouldn't miss this one, girl. Good to see you. Thank you for your super chat. Let's see. Driving but listening. Be careful. Putting money on your books for root beer candy. Oh my God. I have got some crazy Sarah Boone updates. I check out Tanika's 2 cents and she has gotten all these docs. So get this. Sarah frickin' Boone. Oh, damn. Sarah Boone was contacted by some weird thing that she thought was for a documentary, and it's like a nonprofit, and they spread awareness about domestic violence. And she's like writing her friend, and she's like, this is another blessing. And I'm thinking, is it a blessing, or do they want to showcase your story to show that men are domestically abused too? She totally thought it was going to be, well, I don't know if it is or not, but he's not offered a plea though. Oh, trying to figure out if they uncover this other info. Oh, I got you, Looney Tunes. Like, hey, we got this shit on somebody else. Can he work with y'all on this? I got you. Mm-hmm. I'm wondering if it has something to do with Disney. Yeah, I don't know, Tabby. Wouldn't surprise me none. Hey, Cranky. Hey, Melissa B. I'm willing to say more about men. More men are abused of women because, for some reason, women think they have the right to slap men. Hey, Amanda. Right, I think she'll be portrayed as the monster. But she was like, this is just another blessing. She's so crazy. Hey, Buckeye. Hey, Dreams. All right, we're about 4 minutes out. Let's get to our live stream. This is WKMG, and if they don't start it on time, let me refresh it, by the way. Just to be sure. Okay. If they don't start on time, there is Fox and Spectrum. So I think we'll be okay with them. No, he's got a public defender. Yeah, I think Stearns might be dangling other info to cut a deal. I hate his face. It turns my stomach. Oh, me too. He has lost some weight. This is a suppressions hearing. He's trying to suppress some of the evidence that was found on his cell phone. He wants it thrown out. So the state said they have witnesses ready to go. So So the state is putting witnesses on the stand. I don't know if it's going to be the cell phone, like Celebrite person, or the person who analyzed his deets. I'm not quite sure. I don't think he deserves an offer either, Crimes. And being that Florida executes people like him, I don't think he's going to get an offer. I don't think so. I really don't. His salty. His whiny jail calls. I know. There's no jury present. No. Hey, Megan. No jury today. This is a suppression hearing. It's 3 hours. Yep. It's a 3-hour long suppression hearing. So we're going to be here from 2 to 5. Welcome, Donna. This is a death penalty case. Yes. The murder trial. Well, this one is for the CSAM, right? Didn't they say in the interview with Maddie's mom, the detective showed her pics? Yeah, she did. She wanted to see him. She asked to see him. Good morning, Jenny Dubs. She said, can I see it? And he's like, are you sure you want to see that? And she's like, yes. Hey, Flash. Yeah, I mean, Florida executes these sons of bitches, so very rarely is there mercy shown. Very, very seldom. Let me go back a minute here and see. Because I know Fox Orlando was airing it too. Yeah, Fox is live. Okay, they're not showing anything yet. We can look at the Dolphins. But at least they're live. You can look at flamingos and stuff. A win in this case is an aggravator for DP in the next case. Thank you for explaining that, Global. The jury trial for these charges are currently scheduled for 5/5 at 9 a.m. Thank you, Kels. You guys can get some Florida scenery while we wait. April, how you doing? I think so, yeah. I think they just gave her immunity on that one interview. So anything that she said in any other subsequent interviews can be used against her. Let's see what he's saying. Good old Garrett. Let's see if they're going to have streaming.
Live on Fox Local, fox13news.com, fox35orlando.com, and also on YouTube. We've got a lot ahead of us here on this afternoon's show, including, let me give you a live look inside a courtroom in Osceola County where Stephan Stearns is due back in court for a second straight day. Again, you see the judge inside the courtroom. This is for a suppression hearing. Stephan Stearns.
Okay, we need to find one with audio, please. Are you kidding? Here we go.
Motion to suppress evidence obtained from Google search warrant. Some of the arguments are interlaced amongst themselves. The state of Florida has filed responses to each of the motions. In advance of this hearing, the court was provided with 3 audio recordings of interviews. The first recording of an audio interview was with Mr. Stearns and Detective Hunt. That was on February 27th.
They're adjusting it.
12:05. Second recording was identified as 24-11313.
Is it in both ears?
Stephan, between Mr. Stearns and Detective Tagler and Detective Aosta. Third recording the court reviewed was identified as 24-1313 _ Stephan number 2. and that was an interview that occurred on February 28th at 12:16 a.m. I have reviewed those recordings in their entirety. I have reviewed the defense's
I'm scared to
motions.
boost the audio.
Interrelated arguments are that the seizure of Mr. Stearns' cell phone by law enforcement was initially pursuant to consent, but if that consent is deemed valid, that the scope of the consent was exceeded by law enforcement, that consent and subsequent consent were not a knowing, voluntary, or intelligent waiver of his Fourth Amendment rights. That's either that was by way of coercion or acquiescence to police authority or impairment by lack of sleep or ingestion of a sleep aid, and that no exigent circumstances existed to vitiate the need to secure a warrant prior to the seizure. Second motion deals with a request to exclude evidence pursuant to the exclusionary rule, pursuant to an unlawful search of that cell phone. Again, the defense argues that any consent scope was exceeded by law enforcement, that alleged consent was not a knowing, voluntary, or intelligent waiver of Mr. Stearns' Fourth Amendment rights against unlawful search and seizure, again, by way of coercion, acquiescence to police authority, impairment by lack of sleep or use of a sleep aid, and that no exigent circumstances existed for the unlawful search. Third interrelated motion is a fruit of the poisonous tree argument that the subsequent information obtained from a Google search warrant from the initial search and seizure of the phone was pursuant to a warrant. However, the taint was not diminished. The taint of illegal activity was not diminished by the subsequent warrant, that the warrant lacked probable cause, and that the application for the warrant itself were defective on their face. The state's response is also interrelated on these related motions, indicating that the initial interaction regarding the search and limited seizure of the phone regarding the Google search was consensual. That subsequent consent was knowing, voluntary, and intelligently given to law enforcement, that there was probable cause for the seizure of the cell phone, and that exigent circumstances indeed did exist.
I hope they fix the
as to
audio.
the motion to suppress evidence obtained from the Google search warrant, that there was indeed a warrant in this case, that the burden would fall upon the defense to establish standing, and that a recitation of their argument is not evidence to be considered to shift the burden. They also indicate that the warrant had the requisite temporal and peculiarity requirements, and if defective, that law enforcement relied on a good faith exception to conduct the investigation of the Google information. So as to the initial motion to suppress evidence obtained by unlawful seizure of the cell phone, does the state concede standing?
No, Your Honor.
Hey, T-Dub.
Thank you. Defense?
The defense will invoke the rule of sequestration and call Mr. Stephan stands.
Thank you. The rule of sequestration has been invoked. If you are a potential witness in this case, we're going to ask you to please remain outside of the courtroom. Please do not discuss the facts of the case with anyone, including other potential witnesses. Ms. Smith, whenever you're ready. Mr. Stearns may be questioned from counsel table. We're going to swear in Mr. Stearns.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, can you please state and spell your last name for the record?
Stephan Stearns, S-T-E-R-N-S.
And Mr. Stearns, did you come into contact with law enforcement in January of 2024?
I did.
During your contact with law enforcement, did they seize or take an item from you?
Yes, they did.
What item was that?
That would be my cell phone.
Do you know what type of cell phone it was?
It was a Samsung Galaxy, I believe it was a 24.
And what was your understanding, if any, as to what they were going to do with it?
They were just going to check my Google Maps and check to see if I was logged into Google, and that was it. That was all I agreed to.
Were you shown, or did they have a warrant?
They did not.
No further questions, Judge.
Thank you. Any cross requested?
Yes, Your Honor.
Thank you. Ms. Fennell?
Can I have just a moment?
Yes.
I told Sarah to tell them their mics are too loud.
Mr. Stearns, you briefly discussed having a conversation or being interviewed by Detective Tagler and Detective Aosta on February 27th. Is that correct, of last year?
That's correct.
And pursuant to the questions you were just asked, you had indicated that you did not consent to the search of your cell phone.
I consented only to them looking at the Google Maps and checking to see if I was logged into Google in the first place.
What? Can't even understand.
Did you have the opportunity to see what law enforcement was doing on your cell phone?
No, as Aosta was still talking to me, Tagler walked away and began searching all the things that I did not consent to.
Isn't it true that she actually handed your phone back to you?
Right, Vivian, it won't.
She told me to input my PIN because it had locked itself.
And Detective Tagler actually mentioned looking at your history, which you okayed, correct? Your Honor, can we approach?
Yeah, come on up.
Hey, Brendan. Why does my dog scratch on the carpet? Do you know why dogs do that? I think they're working on it. See, they just worked on it.
And the cell phone in question was in fact
Hold on.
your cell phone.
Yes, it was.
I'll turn it up.
I don't have any other questions.
Thank you. Can you redirect?
Much better.
Thank you.
Much better.
Argument, state.
No, Your Honor.
Court's going to find that there has been record evidence to establish that Mr. Stearns was the person that was affected by an alleged violation of his Fourth Amendment rights, that the property alleged in that violation was admitted to be his, and I'm going to find that the burden has indeed shifted to the state regarding the defense's motion to suppress evidence obtained from the unlawful seizure and search of the cell phone. State, do you anticipate presenting witnesses or evidence?
Yes, Your Honor.
Thank you. I'm going to call your first witness.
The state will call Detective Francis Hunt.
Detective Francis Hunt, first witness. Detective Francis Hunt. So this is going to be the woman probably that we heard in all those interviews. He let them willingly have it overnight. You're screwed, Stephan. Dum-dum. Dum-dum. Always ask for a lawyer. But you don't even deserve that knowledge. Oh, where's Sarah? Sarah! I think that was Sarah right there.
Do you solemnly swear or affirm the testimony you are
Oh, it's a guy.
in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Francis is a guy. Yours digs in his bed? Yeah, she does it before she lays down. It must be a dog thing.
Of course. Attorneys on both sides are welcome to move about the well as they need to.
I wonder if he did the extraction.
Good afternoon. Will you please say your first and last name and spell both of them for the record?
Francis, Francis, Hunt, Hunt.
How are you employed?
I'm a detective with the Orange County Sheriff's Office.
What was your assignment with the Orange County Sheriff's Office in February of 2024?
I was and am currently assigned to the domestic crime squad.
How long have you been assigned to that particular squad?
About a year and a half.
How long have you been with the Orange County Sheriff's Office?
About 5 years.
Were you assigned to the investigation into Madeline Soto, who was reported missing?
Thank
Yes,
you,
ma'am.
Shaggy.
Did you have the opportunity to come into contact with somebody identified as Stephan Stearns?
Yes, ma'am.
When did you have contact with Mr. Stearns?
The morning of February 26th, 2024.
February 26th, the Monday, or February 27th, the Tuesday?
I believe it was the Monday, it was actually the Tuesday morning, I'm sorry.
Tuesday. At the time that you had contact with Mr. Stearns, had the Orange County Sheriff's Office already been investigating the disappearance of 13-year-old Madeline Soto?
Yes, ma'am.
Did you have contact with Mr. Stearns and conduct an interview about 12 in the afternoon on February 27th of 2024?
Yes, ma'am.
And can you describe Mr. Stearns' demeanor during your encounter with him?
Nothing particularly notable. He seemed to have, I think he had just woken up about an hour before I made contact with him. He was an average demeanor, nothing particularly notable about it.
Was he cooperative with you?
Yes, ma'am.
Was he able to speak coherently to you and answer questions appropriately?
Yes, ma'am.
Did he seem to have any difficulty understanding the conversation that you guys were having?
Not at all.
Was this interaction that you had with Mr. Stearns audio recorded?
It was.
Where were you at when you had this interaction with him?
I was at his home or at Jennifer Soto's home in Kissimmee. We were in my vehicle.
Was this located at 4012 Santa Maria Drive in Kissimmee?
That's it.
And was anybody else present during your conversation?
No, ma'am.
Your Honor, I would like to approach the witness with state's name for identification.
Drummer.
Did you have an opportunity to listen to the recording on state's A for identification?
Yes, ma'am.
Is it a fair and accurate recording of the conversation that you had with Mr. Stearns on February 27th of 2024 at approximately noon?
Yes, ma'am.
Your Honor, at this time, the state will seek to introduce an evidence of what's been
Let's hear it.
A for identification, and the evidence is stage 1.
No objection.
A as an alpha will be received as stage 1 for purposes of this hearing.
During your interaction, you had indicated that you believe, well, actually here in court today, you indicated that you believed he woke up about an hour before you had contact with him.
I believe so.
What makes you say that?
I had first completed an interview with Jennifer Soto. I had gone back to my vehicle to make a phone call, and I think Stephan was upstairs in the home while I was interviewing
In room number 4.
Jennifer. When I had gone back in, he walked back down from upstairs and said that he had recently woken up within the hour.
Sleeping, he said. Wow.
Can I add just a moment, Your Honor? No further questions.
Cross-examination.
Good afternoon, Detective.
Good afternoon.
So just to be clear, when you're doing this interview, you're inside of the house, right?
I was in my vehicle.
Okay. When you first met with Mr. Stearns, you met him inside the house?
In the house, yes, sir.
Okay. And then you took him outside and put him in your vehicle, right?
Yes, sir.
And when you did that, that's when you learned about him being sleepy, it sounds like?
I don't think he was sleepy, but it sounded like he had woken up about an hour prior. Yes.
Okay. Woke up about 11 a.m.? It sounds like he was noonish, right?
Correct.
At any point, did you ever seek a warrant for any of the cell phones or anything in this case?
Oh, no, sir.
Okay. Did you ever look at a cell phone?
No.
Did you ever ask him about a cell phone?
No.
Brief note? Of course. Any other questions?
No, Your Honor.
Detective Hunt, step down.
Yes, Your Honor.
Is he excused from subpoena for today?
Yes, Your Honor.
Thank you, Detective.
Yeah, I don't really think he looks skinny either.
May I call your next witness?
State calls Detective Myra Tagler.
Detective Myra Tagler. Gross.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Feel so bad for these people that had to see all these
Say your
images.
first and last name and spell both of them for the record.
Myra Tagler, M-A-I-R-A, last name T-A-G-L-E-R.
How are you employed?
The Orange County Sheriff's Office,
How long have you been with the Sheriff's Office?
9 years.
In February of 2024, what was your assignment?
I was assigned to the Sex Crimes Unit.
Are you still assigned to that particular unit now?
Yes, ma'am.
How long have you been in that unit?
3 years and 2 months.
Were you working in your capacity as a detective in that unit on February 27th of 2024?
Yes.
Did you become involved in the investigation into the missing juvenile named Madeline Soto?
Yes.
How did you become involved?
I was tasked to assist the primary detective at the time, Detective Hunt, with canvassing.
About what time do you respond to assist in the investigation?
It was about 4 p.m.
And this was on February 27th.
Yes.
And where is the initial location where you responded to?
It was in Hunters Creek,
Did you respond to a residence in Hunters Creek or somewhere else?
somewhere else.
Did you respond to the command post?
Yes.
When you get to the command post, do you learn any information regarding the investigation?
Yes.
What information do you have after leaving the command post? What information did you get?
I was advised of we have LPRs, which is tag readers, and I was advised of the direction of travel that Stephan's vehicle had traveled the day of the incident.
Were you aware on this date and time that Madeline Soto had not gone to school on February 26th?
Yes.
Were you aware that she had not been seen since the morning of February 26th?
Yes.
And the information regarding the tag reader, did law enforcement identify the tag that was on a vehicle that the defendant had access to?
Yes.
And what was some information that you got regarding the location of the defendant's vehicle on the morning of February 26th, the Monday?
He had traveled southbound 3 times on South Jungin Parkway towards Kissimmee, which was away from the direction of Madeline School.
Are all of these times early morning and late morning?
Both.
And then did you also get some information that in the afternoon, the car was traveling in and out of St. Cloud, Florida.
Yes.
Specifically, the travel on southbound South John Young Parkway, were those times consistent with what the defendant had described to law enforcement as his location were?
They were not.
And were these, the initial time was around 8:15 in the morning?
I believe it was 8:10.
And then there was another one around 10 o'clock in the morning?
Yes.
And then almost around noontime?
Torso, you guys are terrible.
Thank you. Overruled as to leading. I've got a question. The times that you just gave were for identifications of the tag through the LPR system.
And then the afternoon times of going in and out of St. Cloud, do you recall what those were?
I do not.
Did you document those times and locations in your narrative that you drafted for the
Yes.
case? Would looking at your narrative assist in helping you remember the specific times that the vehicle was traveling in and out of St. Cloud?
Yes.
Your Honor, I'm approaching the witness for the record with Detective Tagler's 11-page narrative.
Thank you. I'm looking at page 4.
Hey, baby D.
Does page 4 help refresh your memory as to the times that the vehicle was picked up on the Tagler going in and out of St. Cloud?
Yes.
What times was it traveling towards or into St. Cloud?
It says eastbound on US 182 and Pecan Street at 13:05 hours, and westbound on US 192 and Academy Drive at 14:23 hours.
And you were equipped with this information at the time that you responded and met with Mr. Stearns in this case?
Yes.
Were you aware as to who the last person to have seen Madeline Soto alive or have seen her was?
Yes.
Who?
Stephan Stearns?
Was that consistent throughout a lot of law enforcement interviews that were conducted?
Yes.
After you get this information and your task is to assist in the investigation, what's the next thing that you do?
Detective Aosta and I respond to Kissimmee to their residence, and we meet with Detective Hunt.
When you say their residence, are you referring to Ms. Jennifer Soto and Madeline Soto's residence?
Yes.
That would be on the Santa Maria Drive.
Yes.
When you get to the address, who is there?
Detective Hunt is there. There's other patrol deputies on scene, and Jennifer and Stephan.
Is there law enforcement conversing with either Jennifer Soto or Stephan Stearns?
Not at the time.
Who is the first person that you speak with?
Detective Hunt.
Does Detective Hunt relay information that he obtained during an interview with the defendant to you?
Yes.
What information do you recall receiving prior to your interaction with the defendant?
He stated that he had spoken to Stephan and Jennifer, and to his knowledge, Madeline had not made it to school, that Stephan had dropped her off near the school, and that they were supposed to go to McDonald's, but they didn't. And then he watched her walk towards the direction of the school, and then he went home.
Did
McDonald's.
you receive at that time any information about the sleeping arrangements on February 25th of 2024, the night before?
Yes. Detective Hunt told me that Madeline and Stephan had slept together in room number 4 because Jennifer needed to get more rest that morning.
Ugh.
Equipped with this information, did you come into contact with Stephan Stearns?
Yes.
How did you know who was Stephan Stearns
Thank you, Salty.
and how to find him in the area?
Detective Hunt pointed him out.
Welcome, Lynn.
Was your encounter with Mr. Stearns audio recorded?
Yes.
As a detective, what is your uniform, for lack of a better word, when you are at work? What do you wear?
Professional attire, like I'm dressed right now.
You're not in a police uniform when you make contact with Mr. Stearns?
I am not.
How about Detective Louis Acosta?
Same, not in uniform.
Does anybody approach Mr. Stearns with you and Detective Acosta?
No.
Where is Mr. Stearns when you approach him?
We're all standing behind his vehicle.
When you say his vehicle, who are you talking about?
The Lincoln?
So the defendant's Lincoln.
Yes.
And at this point in time, is the defendant handcuffed?
He's not.
Is the defendant free to leave?
Yes.
How is his demeanor, his meaning the defendant's demeanor when you're interacting with him?
He was very emotionless, but otherwise able to answer every question that we had for him.
Did he, the defendant, seem groggy, confused, unable to communicate with you?
He did not.
Did the defendant respond appropriately to questions that you were asking?
He did.
Would you classify his behavior towards you as cooperative?
Yes.
Can you explain to the court, I know that you indicated that you're all standing in the back of Mr. Stearns' vehicle, but can you explain to the court where everybody is positioned?
Yes. I was standing on the left side of the trunk. Stephan Stearns was standing directly next to me. We were basically shoulder to shoulder. And Detective Acosta was standing closer to the wheel well on the right side and the corner of the car.
Was Mr. Stearns' path of travel impeded by either of you?
It was not.
Was Mr. Stearns free to leave?
Yes.
Did Mr. Stearns ever communicate with you either verbally or by body language or physically a desire to end the communication with you?
He did not.
At some point during your interaction with him, do you request for Mr. Stearns to take out his cell phone?
Yes.
Or to look at his cell phone?
Yes.
Can you remember where the cell phone was, where the defendant's cell phone was when you asked this question?
I do not. It was in his possession, but I don't recall where he grabbed the phone from.
Did the defendant consent to allowing you to look at his phone?
Yes.
And do you remember if Mr. Stearns' cell phone was password or passcoded protected?
It was.
Who entered the passcode into the phone?
Stephan.
After Mr. Stearns entered the passcode in the phone and unlocked the phone, what did Mr. Stearns do with the phone?
He handed me the phone.
While you are holding the phone, where are you standing?
In the same position next to Stephan.
Do you
Thank you,
hold
Salty.
the phone in a way to allow others to see what is on the phone?
Yes.
Where is Mr. Stearns at as you are looking at the phone?
Directly standing next to me.
And initially, the interaction and how the cell phone comes out, you bring up looking at maps in the phone.
Correct.
Are you familiar with the type of phone that the defendant had?
I am not.
A phone with a lot of bad stuff on it.
Do you also inquire as to taking a picture of, quote unquote, your history, the defendant's history? Do you remember that?
Yes.
And that's also encompassed in the audio recorded interview?
Correct.
Does
Queen
the
Bee.
defendant ever communicate to you any limitations on what it is that you're doing?
He does not.
Does the defendant ever attempt, either verbally, physically, or in any type of way, to cease the search of the phone?
He does not.
After you look at the maps, the history, what did you see? Or what did you notice in what you saw on the phone?
I noticed that he had mentioned that he uses Google Maps for basically everything, to check locations, the time places open and close. And I noticed that on his Google history, it was very minimal. There was not a lot of traveling that was consistent to what he had originally said to both Detective Aosta and I. So then after that, I went to his call history, and I noticed that there was also not a lot of information on his call history.
And this was after you mentioned looking at his history?
Correct.
And during this entire time, did the defendant ever cease or withdraw his consent, either verbally or physically?
He does not.
After this initial interaction with the cell phone, do you keep the cell phone?
No.
What do you do with it?
I hand it back to Stephan.
Now we're frozen.
Is it at this point that you walk away for a brief period of time?
Yes.
And
It's still a little off.
do you come back?
I do.
Where Mr. Stearns and Detective Aosta are?
Yes.
Did anything about the circumstances surrounding this interaction with Mr. Stearns, either the location, the number of people, where people are standing, did any of that change?
No.
Was Mr. Stearns standing in a similar place as before you left?
Yes.
Was Mr. Stearns still free to leave and out of handcuffs?
Yes.
At approximately 7:57, do you again
Welcome,
ask
Salty.
Mr. Stearns to unlock the phone?
Yes.
How does that happen? Explain that process.
He again enters the code and hands me the phone.
Welcome to Clickerville, Salty.
At some point, do you bring up the lack of call history to the defendant?
I do.
What was
Even worse.
the defendant's explanation?
He said he had accidentally factory reset his phone.
After your interaction with him, you knew all of that information that you had previously explained that you knew. You had an opportunity to see things on the phone. And the information that you had that the phone was factory reset. What did you do?
At that point, I told him I was going to hold on to his phone.
And that was approximately at 8 p.m., 7:59, 8 p.m. on February 27th of 2024.
Correct.
After this interaction with him, did you secure anything else?
No.
Other than the cell phone, did you secure anything else or?
Well, I did ask him to refrain from going back in his vehicle.
His vehicle meaning the Lincoln?
Yes.
Was Mr. Stearns able to enter and exit Jennifer Soto's vehicle during the time between your two interviews with him?
Yes.
Was he free to walk about?
Yes.
Did you or Detective Aosta remain where Mr. Stearns and Ms. Soto were?
No.
What were you doing in between your two interviews?
After speaking with Stephan Stearns the first time, Detective Aosta and I went to the front of the apartment complex to speak with management and ask them to review their surveillance.
After doing these additional tasks, do you speak to Stephan Stearns a second time?
Yes.
This is approximately 12:15 in the morning on February 28th, right?
Yes.
Was Mr. Stearns handcuffed?
He was not.
Had his movements been restricted in any way by you during your conversation?
No.
Were you wearing the same clothes that you had worn a couple hours earlier?
I was.
Who was with you when you spoke with Mr. Stearns?
Detective Aosta.
At any point in time during either of your interactions with Mr. Stearns, did you or Detective Aosta remove a firearm from your persons? Did you guys take your guns out?
No.
Did you
You just
threaten
heard a stop.
arrest or anything like that during your interactions with Mr. Stearns?
No.
This second interview that you conducted, was that also audio recorded?
Yes.
Was Mr. Stearns free to leave at the end of the interview?
Yes.
In fact, he did leave your presence as well as Mission Bay, correct?
Correct.
Was Mr. Stearns' demeanor the same or different?
It was the same.
Did you have any issue communicating with Mr. Stearns?
I did not.
Was Mr. Stearns cooperative with you?
Yes.
And during this second interview, did you explain what law enforcement was seeking to do with Mr. Stearns' phone?
I did.
What did you tell him?
I asked him we wanted to, or I told him that we wanted to download the phone to see if we can get more information from his maps, and then he said that that was fine.
Okay. Are you sure that you specifically said that you wanted to download information, specifically the maps?
Not just the maps, just any information on his phone. I told him that we wanted to get more information from his cell phone.
Do you remember using the words, we want to download your phone, we want to go through your phone?
Yes.
During this encounter with him, you request specific consent from him to be able to go through the phone, right?
Yes.
Do you explain to him in your question what is going to happen or what your alternative route to obtaining that cell phone download is?
Yes.
What did you say?
When I explained to him what we wanted to do with the cell phone, I asked him if I had his consent to download the phone or if I had to obtain a search warrant.
And did the defendant consent to downloading the phone?
Yes.
Did the defendant provide you verbally with the passcode to his phone?
He did.
At the time that this interaction happened, did you or Detective Aosta impede or restrict Mr. Stearns' movement in any way?
We did not.
At any point in time, did Mr. Stearns seek to limit the scope of the cell phone download?
He did not.
Did you provide Mr. Stearns with your phone number or a way to get a hold of you after your interaction?
I did.
And did you give him any information as to when you would be accessible through that cell phone?
I did.
What did you tell him?
That my phone was on 24/7.
At any point in time, did Mr. Stearns reach out to you to either withdraw consent or limit the consent?
He did not.
Are you sure that he had a way to communicate with you?
Yes.
How do you know that?
Because Jennifer had her cell phone with her.
Are you sure that, do you know if Mr. Stearns and Ms. Soto left Venetian Bay together?
They did.
Do you know which vehicle they were in?
In Jennifer's vehicle.
I'm approaching the witness for the record with State's B for identification. Did you have an opportunity to listen to the recordings on State's B for identification?
I did.
Did they fairly and accurately depict the recordings of the 2 interviews that we discussed here in court with yourself, Detective Aosta, and the defendant in this case?
Yes.
Your Honor, at this time, the State received interviews and evidence what the marked B for identification and evidence of State 2.
Be a composite exhibit with both recorders?
Yes, Your Honor.
Thank you.
No objection.
These and Bravo will be received as State 2.
Can I have just a moment? No other questions.
Cross-examination?
Good afternoon, Detective. So your interactions with Stephan Stearns, they were audio recorded, right?
Correct.
Okay, they weren't video recorded?
No.
Okay. And let's paint that picture. When you arrived on scene, you said that it was you and another detective present, right?
Correct.
Actually, I think it would have been 3 detectives, right? You, Aosta, and Hunt?
Hunt was already on scene. Detective Aosta and I arrived later.
Okay, so 3 detectives now on scene.
Correct.
Okay. And alongside those detectives, you said that they were patrol deputies, right?
Yes.
From the Orange County Sheriff's Office?
I don't recall if it was us or Kissimmee.
Okay. Were they wearing uniform?
Yes.
Did they have their badges?
Yes.
Did they have their guns?
Yes.
Did you have your gun?
I did.
Okay. And did you have their badge?
I did.
Okay. And when you arrive on scene, you said that you first went to talk to Detective Hunt, right?
Yes.
Okay. And then afterwards, at one point you start talking to Stephan Stearns, right?
Yes.
Okay. And this is outside of his house?
Correct.
Because it's not allowed to go inside his house at this point, right?
Not at this point. The house was not secured.
Right. And when you're talking about secured, that's for securing for searching the house, right?
Correct.
Okay. So the deputies are making sure that he's not going back inside his house, right?
Nobody's doing that.
Okay. So at what point, let me ask it this way, how did he get outside of the house?
I don't know. I wasn't there when he was outside.
To your understanding, how did he get outside?
I'm not sure.
The law enforcement have told him to?
I wasn't there.
Okay. And when you're talking with him, at no point did you say, you can go back inside, right?
I did not.
At no point did you say, you're free to leave, you can drive away, right?
I did not.
Actually, and you kept him from going inside his own vehicle, right?
I did.
Because that was being secured for searching too, right?
At that time, I just asked him to refrain from going back in his vehicle.
Okay, so you didn't even tell him it was for search?
Not at that time. I wasn't sure what we had at the moment.
Okay. And then when you're talking with Mr. Stearns, you kind of give us a general overview that you said that he consented to searching his phone, right?
Yes.
Okay. Your specific question to him at first, going through the timeline, is do you mind if I look at your maps real quick, right?
Correct.
At no point did you say, do you mind if I dig through your entire phone at this point, right?
I did not.
Okay. And then when you get to the next question, it's do you mind if I take a picture of your history, right?
Yes.
Okay. Not take a picture of his lock screen?
No.
Not take a picture of his home screen?
No.
Not take a picture of his call history?
It was his history.
Not take a picture of his emails?
I did not.
Not take a picture of the entirety of his phone, just his history, right?
Correct.
Okay. And then when you get to the next thing, you say, is it okay, let me make sure this is right. Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google, right?
Yes.
And at that point, Mr. Stearns tells you that he is not logged into his Google, right?
Correct.
Okay. But then you keep pressing and you say, is it okay if I check?
I asked. I didn't press.
You asked if it's okay you checked?
Yes.
Okay. And at that point, it was just to check whether he was logged into his Google, right?
Correct.
Not going through the entirety of his phone.
Correct.
You never asked him, can I go through the entirety of your phone?
He was standing next to me while I was on his phone.
Okay, so it's your basis that he has to say no, you can just keep digging until he says stop?
Correct.
Really?
He was standing next to me and he saw what I was doing on his cell phone.
And did you ever ask him to go through the rest of your cell phone?
I did not.
Did you ever ask him to go into his call history?
I did not.
Did you ever ask him to go through his Google Drive on the phone, if it was there?
I never looked at his Google Drive.
Okay. But you were looking at the rest of his phone, right?
I looked at his call history and his Google Maps.
Okay, because you were trying to figure out that timeline, right?
Correct.
It's the only thing you were looking for at this point, right?
Correct.
Okay. Did you ever go into the photos on his phone?
Yes.
While he was there?
Yeah, he was standing next to me.
Okay. Did you ever ask him if you could go through his photos?
I did not.
Right. And when you're going through those photos, I mean, let's talk about that. How many of his photos did you look at?
I think it was maybe 2 or 3 of the day Madeline went missing.
Just to be clear, you're not just looking at like the big grid, you start going into actual pictures?
I don't recall if I actually clicked on any of the pictures.
Okay, so how do you know that you were just looking at 2 or 3 of those?
Because it has dates on, like if you look at the grid, it shows dates for pictures.
Okay. And at any point, I'll just rephrase, at no point did you ask him to look at his photos?
I did not.
Hi, Cramit.
Then you go back to his Maps app at some point, right?
Correct.
And at that point, you're talking to him about the Snug Street address, right?
Yes.
Okay, and you never asked him if he could go back to the Maps app at that point, right?
I did not.
Okay. And just to be clear, nothing is visually recorded at this point. Right?
Correct.
So when you say that you handed him his phone back, you never actually said, hey, here's your phone back, or anything like that?
I did. I said, here you go.
Here you go. Now, when you get the phone back from him, what do you say?
I said, can you please unlock your phone again?
Okay. And at that point, it was still you and Detective Aosta standing with him, right?
Correct.
Because you both are kind of tag teaming him, questioning him, right?
Tag teaming?
We're both talking to him.
Okay. Specifically, at what point did you say, here you go, when you handed him his phone?
Right before I stepped away.
Okay. You sure here you go are your exact words?
I don't know if it was my exact words, but I did hand him the phone and I said, here you go. It's in the audio recording.
She's doing a great job.
Okay. And then at this point, you said you got him to unlock his phone again, right?
Yes.
And that's when you started digging through his call history, right?
I'm not sure what I looked at when I had the phone back.
Well, you specifically said, I also noticed I was checking your call history. I noticed you don't have anything before this morning, right?
Yes.
Okay. And at no point did you ask if you can go into his call history?
I did not.
You took the phone from him, what time was that?
About 8, a little after 8.
8 at night?
Yes.
Okay. Just to make sure we're painting that picture clear too. 8 o'clock at night you're speaking with him, right?
Correct.
It's about 50 to 60 degrees outside?
Correct.
Okay. And law enforcement's been standing around with Mr. Stearns outside?
He went to Jennifer's car after me and him spoke.
Okay, but before you and him spoke?
I can't answer that question. I wasn't there.
Okay, when you first showed up, where was he?
Outside.
Outside where?
I don't recall the exact location, but he was outside with Jennifer.
Right, so you know exactly where you walked, but not where he was?
Correct. I walked towards Detective Hunt.
Now, at this point, you collect Mr. Stearns' phone away from him for the final time that he has his hands on, right?
Correct.
And when you take that phone away from him, you don't ask him for his phone. You take it from him, right?
I already had the phone.
Oh, right. And then you told him specifically
Trying to
that,
trip her up.
At this point, we're keeping your phone.
It's all
Correct.
recorded.
Okay. Didn't give him a choice.
I said, I'm going to keep your phone. We want to download your phone.
And then she said, is that okay? And he said yes.
Excuse me. What was the exact phrasing that you just said there?
That we wanted to download the cell phone.
You said that during the first interview.
The second interview, not the first
Second.
one.
Talking about when you took the phone away from him the first time during the first interview. When did you tell him that you were going to download the phone?
The second time.
During the first interview, when did you tell him that you were going to download
The second time I spoke to him, not the first time.
You never said it first.
I did not.
Right. And then when you're talking with him that second time, you actually state to him, your exact words are,
Objection improper impeachment.
response? I'll rephrase it. When you speak with him, did you tell him that we had previously said that we were going to download the phone?
Yes.
And your interactions with him were recorded?
Correct.
I agree, Dreams.
And when you originally took the phone from Stephan Stearns, Mr. Stearns was concerned about staying in touch with his father, right?
Correct.
Okay. And that's the point where you told him, well, you can just talk to him through Jen's phone, right?
Yes.
I hear you, brutally honest.
And at no point was he asked to consent to seizing his phone, right?
Correct.
At no point did you ever give him any form or anything to consent to seizing his phone?
I did not. Everything's audio recorded.
Okay. And at no point did you ever get a form from him consenting to downloading his phone?
I did not.
Okay. Because everything's audio recorded.
Correct.
Got it. And you collect the phone at 8 at night. It's about 1:30 in the morning you're talking to him again.
It's not. It's about midnight.
About midnight, okay. 4 hours then?
Just about.
Okay. You had the phone in your possession?
It was in my vehicle.
Okay. Ever apply for a search warrant at that point?
I did not.
Okay. Why not?
I didn't need. I didn't have like enough information yet as to what we were doing with the case.
Elaborate on that.
It was premature.
What do you mean you didn't have enough information?
We knew that something didn't sound right, as like was speaking with him with like the timeline and things like that. But we weren't sure exactly what we were doing yet. I was waiting for my supervisor to contact me.
Okay. And when your supervisor contacted you, did he or she, excuse me? He? Did he tell you to get a warrant?
He did not.
Okay. Did he tell you to try and get that cell phone downloaded?
He did.
Okay. And how did he tell you to get that cell phone downloaded?
He didn't. He just said we wanted to get the phone downloaded, and that's when I asked Stephan if I had his permission to download the phone or if I needed to get a search warrant.
Right. You gave him the ultimatum at that point, right?
I asked him 2 questions.
Okay. So we can either get the phone or you can get a warrant, right?
Correct.
Now, at any point during these interactions, did you ever tell Mr. Stearns that he could have his phone back?
I told him his phone was going to be downloaded overnight and that he should probably get it in the morning.
Okay. And prior to the second interview, did you ever tell him he could have his phone back when you just took it from him?
I did not.
Okay. At any point, did you ever apply for a search warrant to download Mr. Stearns' phone?
I did not.
Did any other detective do that?
No.
Okay, because you're relying on that consent, right?
He gave us consent to search his phone.
It's a yes or no. Were you relying on the consent or did you get a warrant?
He gave me consent.
Now, when you're speaking with him, you became aware that Mr. Stearns had taken medication, right?
He said he had the night before.
Okay, and that was Ativan?
Yes.
And he told you why he took that medication, right?
Because he said he couldn't sleep and that he was very stressed and couldn't stop crying.
Right, and then he was also having panic attacks, right?
Yes.
Okay. And you knew that?
Yes, the night before.
Why your question? During the first interview?
Correct.
And the second?
Correct.
Got it. You aware what Ativan does?
I don't take Advance, so no.
Okay. You ever deal with anybody that taken Ativan?
No.
Objection relevance.
As to Mr. Stearns he was wearing flip-flops at the time, right?
Correct.
Khaki shorts,
Yes.
thin hoodie.
Yes.
Told you he hadn't eaten all day, right?
Yes.
And was prevented from going inside of, sounds like his vehicle, right?
His vehicle, correct.
Okay. And again, couldn't go inside his own house. Or not his house, but the apartment.
Not at the time.
Okay. And at what time, rephrase, at 2:40 in the morning on February 28th, you submitted his phone to the Orange County Sheriff's Digital Forensics Unit, right?
I did not.
You did not?
No.
Who did?
Detective Acosta.
Okay, so Detective Acosta was now in charge of the phone?
Yes.
Okay. You guys ride in the car together?
We did not.
You said the phone was stored in your car at some point, right?
When we were talking, or when we were looking at the video, yes, it was in my vehicle.
When did you turn over the phone to Detective Acosta?
Chain of command.
At the end of the night, after we secured the residence, which was around 1 in the morning, Detective Acosta was waiting for the tow truck for Stephan's Lincoln, and that's when I handed him the phone because he was going to Central Operations, and I was not.
Was that the last time that you had involvement with the phone?
Yes.
Okay. So after the handoff, nothing else, just to be clear.
In reference to, like, if I ever looked at the phone again?
Yeah.
Sure, I think it was like 2 days later.
Okay. So at that point, the phone's still in your law enforcement's possession?
Yes.
Brief moment to confirm? Of course.
Thank you, Amanda. All because Stearns doesn't understand the concept of consent. The irony. Oh, Amanda. The irony is right.
Thank you. Redirect.
Thank you for being a member for 5 months.
Defense mentioned that there were other law enforcement personnel that were at the apartment complex. During your interactions with Mr. Stearns,
Thanks for your input, Kelly.
who was in the immediate area?
We're not
Just
watching a
myself and
circus.
Detective Acosta. Everybody was kind of just hanging out in the area.
It's a court hearing. I don't know what you expect, Kelly. A circus? A 3-ring circus?
I don't have any other questions.
Detective Tagler, I've got a question. When you initially interacted with Mr. Stearns, you indicated that you were going
When is a child
take
porn
photo
case exciting?
of his history, is that correct?
Yes.
Did you take a photo of his history?
Yes.
All right. Was that on your agency cell phone?
Yes.
Any follow-up questions based on that question? State.
No, Your Honor.
Defense? No. Thank you. Detective, step down.
Yes, Your Honor.
Detective Tagler, excuse.
Yes, Your Honor.
Detective Tagler,
Thank
step
you.
down. Thank you. This is your rep.
Yes, Your Honor. Detective Lewis Acosta.
Raise your right hand to read for.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Sid. This is all a part of justice for Maddie. Every part of it. Every single part of it. Have respect.
Please say your first and last name and spell both for the record.
Louis Acosta, Luisacosta.
How are you employed?
Orange County Sheriff's Office as a detective.
Can How long have you been with the sheriff's office?
5 years.
In February of 2024, what was your assignment?
I was a detective with the Orange County Sheriff's Office Sex Crimes Unit.
How long had you been in that unit at that time?
Approximately 6 months.
Are you still assigned to that unit?
Yes.
How did you become involved in the investigation of missing juvenile Madeline Soto?
I was the secondary on-call detective at the time, and I assisted Detective Tagler with the investigation, going over to the command post. We assisted our missing persons unit at that time.
What information did you learn at the command post?
We learned that Maddie Soto had been missing for a little over 24 hours. She was 13 years old. We knew that the last person who had seen her was Mr. Stearns. Just, that basic information.
Okay. Did you also get information regarding LPR tag reader hits on Mr. Stearns' Lincoln?
Yes.
And you also got the timing of those tag reader hits?
Yes.
Did you respond along with Detective Tagler to 4012 Santa Maria Drive in Kissimmee?
Yes.
And did you learn any additional information prior to speaking with Mr. Stearns at that address?
Yes. Prior, we were briefed of Detective Hunt, who's the initial primary detective assigned, just of additional details. For example, that she slept in the same bed as Mr. Stearns, things like that.
Thank you for being here, Lori.
Did you assist in the interview of Mr. Stearns that was conducted by Detective Tagler at approximately 7:16 in the evening?
Yes.
And this would be on February 27th of 2024?
Yes, correct.
Where did this interview take place?
It took place in the parking lot of their of the apartment complex near the residence, Maddie's residence.
Who was in the immediate vicinity as this interview was being conducted?
It was Mr. Stearns, myself, and Detective Tagler in the immediate vicinity.
Where would you say the next closest law enforcement official was?
At least 25 yards away.
Were all of the law enforcement officials within view of where you were?
The ones that were in the parking lot could see the general vicinity where we were at.
How many law enforcement officials would you say were in the parking lot area of where the interview was conducted?
Maybe 10, fewer than 10.
And were these law enforcement officers engaged in tasks, sitting in vehicle, like what was going on?
Yes, just kind of setting up a perimeter around the area, making sure media didn't get too close, just kind of standing by for tasks.
Scene security?
Scene security.
Did any of these other law enforcement officials have contact besides you, Detective Tagler, and Detective Hunt earlier in the day with Mr. Stearns while you were there?
While we were there? No.
Where were you and Detective Tagler and the defendant standing during this?
Me too, Kiwi.
We were behind the trunk of a vehicle. I can't recall the specific vehicle.
Was Mr. Stearns' ability to move about freely inhibited by either of you?
It was not.
How about any other law enforcement officer that was there?
No.
Were there any law enforcement vehicles prohibiting other vehicles from leaving the area or anything like that?
No.
What was Mr. Stearns' demeanor during your encounter with him?
Kind of very just matter of fact.
Would you classify his conversation with you as cooperative?
Yes.
What were you and Detective Tagler wearing? Not obviously specifics of what you were wearing, but were you in plain clothes?
We were, yes, plain clothes.
Did either of you ever remove your firearms from their holsters?
No.
Did either of you remove any handcuffs, taser, any type of weapon?
No.
Were there any threats of arrest made?
No.
Was Mr. Stearns free to leave?
Yes.
Did Mr. Stearns, based upon your encounter with him, seem to respond appropriately to questions asked?
In what way?
If you asked a question, did Mr. Stearns respond in a way that was coherent?
Yes.
Did you have any difficulty communicating with Mr. Stearns?
No.
Did Mr. Stearns fall asleep or ask to be excused from the interview?
No.
At some point, did Detective Tagler ask Mr. Stearns to look at his cell phone?
Yes.
Do you recall where the cell phone was during this initial interaction?
When she asked to view his phone, he said yes, and it was within eyesight of him. We were right next to him.
Who had the phone when Detective Tagler asked to look at some of the stuff on the phone?
Mr. Stearns had the phone, and then he gave the phone to Detective Tagler after she asked, and he said yes.
Did Mr. Stearns have to do anything to the phone prior to giving it to Detective Tagler?
He input his passcode to get it.
Where was the defendant and Detective Tagler standing while Detective Tagler was viewing the content of the cell phone?
They were standing shoulder to shoulder next to each other.
Were you asking questions at that point?
Yes.
Were you able to see the content of Mr. Stearns' phone?
At some point.
Were you standing next to where Detective Tagler and Mr. Stearns were standing or somewhere else?
Yes, next to both of them.
Was Mr. Stearns facing the general area of where his cell phone was being displayed from?
Yes.
There is a point in the interview where Detective Tagler steps away. Prior to stepping away, what is done with the cell phone?
She gives the cell phone back to Mr. Stearns.
Do you continue to have a conversation with Mr. Stearns?
Yes.
At any point in time, does Mr. Stearns discuss the content of the cell phone or Detective Tagler's looking through the phone?
No, I don't.
At some point, does Detective Tagler come back?
Yes.
And is the cell phone brought out again?
Yes.
At this point, who had the cell phone?
Still Mr. Stearns.
When Detective Tagler asked for Mr. Stearns to unlock the cell phone again, does he do so?
Yes.
Does he have to enter the passcode again?
Yes.
Are the circumstances surrounding this interaction the same as what you described previously as far as location and people involved, the defendant's ability to leave?
Yes.
At the time that that interview concludes, Detective Tagler keeps Mr. Stearns' cell phone, correct?
Yes.
What information did you have together about the Madeline Soto investigation?
So aside from what we had before, that she had been missing for over 24 hours, he was the last person to see her. There were many inconsistencies surrounding the time frame that he stated. He dropped her off and other things, and then the tag readers and information that we had about his movement.
Had the defendant been straightforward with you and Detective Tagler regarding his movements?
No.
I should be more clear. His movements the morning of February 26, 2024.
He told us certain movements that didn't correlate to the information that we had.
Did you confirm with the defendant that he regularly used his cell phone to get places, look up addresses, get store hours, directions, things like that?
Yes, I believe that was brought up.
Were you aware that there was very limited location data and mapping location data that was in his phone when Detective Tagler checked that?
Yes.
Were you aware also of information that was located in Madeline Soto's cell phone as far as communications between her and the defendant?
Yes.
What information did you have about that?
They communicated extensively, including very late at night.
Were you also present with Detective Tagler at the conclusion of this interview between the second interview that was conducted at 12:15 a.m.?
Yes.
What were you guys doing in that interim time?
So in the interim, we were reviewing surveillance video from the apartment complex to corroborate the times that he came back into the apartment complex.
Did you learn any new information when you did that?
Yes. One of the surveillance videos that we saw, it appeared that there was somebody either asleep, passed out, or not awake on the inside the vehicle.
What exactly did you have information as to the last clothing items that Madeline Soto was reported to wear?
Yes.
Was the individual in the driver's seat or passenger seat is what you just described?
Yes, wearing the same.
Were they in the driver's seat or passenger seat?
Passenger seat, front passenger seat.
What about their appearance makes you believe that they were not awake?
Slumped over, kind of leaning back. Just did not appear to be awake.
And you observed this video between the first and second interviews?
Correct.
And the individual that you just described, was that consistent with the characteristics that you were knowledgeable about Madeline Soto?
Yes.
The second interview, were you present at 12:16 a.m. when Detective Tagler again spoke with the defendant?
Yes.
And it was during this interaction where there was a brief conversation. Did you have a brief conversation with the defendant about what was seen in Madeline Soto's phone?
Yes.
Did the defendant attempt to explain that to you?
Yes.
What did he say?
He initially said she thought of him as a father figure. Then he immediately said she thinks of him as a father figure. Just said that it was a father figure-like relationship.
Gross.
And you also were present when Detective Tagler then speaks about downloading the cell phone.
Yes.
Can you kind of elaborate on that encounter as far as
What just happened? Whoa. What in the world? That's weird.
She explained.
We're back.
That we'd be taking the phone, be getting it back whenever the phone download was complete.
So weird when that happens. Like, what? In the middle of.
Did Mr. Stearns limit the download of the cell phone in any way?
No.
Did the defendant refuse to give consent to download the phone?
No.
Did the defendant willingly provide the passcode to his phone?
Yes.
And all of this is recorded, right?
Yes.
I like this view better. I like seeing everybody.
At what point do you recall learning that the phone was factory reset?
I believe during the first interview.
Buddha girl? I agree.
While Detective Tagler was looking through the phone, she noticed that the call logs, he only had calls from that day, the date of the interview, so from February 27th. So she asked him about it, why he only had calls from that date. He said he had accidentally factory reset his phone the day prior, attempting to
hide evidence.
Just some sort of a
hide evidence.
update. There you go.
He hid evidence. Say it for what it is.
As a law enforcement officer, have you had the ability to seize or collect cell phones belonging to individuals during investigations?
Yes.
When a cell phone
no firing
is
squad
taken, are you aware, or do you put the cell phone in airplane mode or secured in any way?
Yes, it's placed on airplane mode.
Why?
To prevent it from being remotely reset or anything being deleted remotely.
So you're aware of that possibility?
Yes.
No further questions.
Cross-examination.
Good afternoon, Detective.
Good afternoon.
So the interactions between you and Stephan Stearns, that was audio recorded, right?
Yes.
Not video recorded?
No.
Okay. And it's my understanding that you have an agency-issued cell phone, right?
Yes.
And that has the ability to document photos as well as videos?
Yes.
Okay. Did you do any of that documentation, the photos and videos, while you were speaking with Mr. Stearns?
I did not.
Okay. When you said you arrived on scene, you said there was about 10 other either deputies or officers on scene?
Roughly spread around the parking lot area.
Okay. And you said that they were securing a perimeter, right?
Correct.
Making sure that media wasn't coming in and out of the apartment complex, right?
Yes.
Okay. So that means that there were going to be officers at the main entrance area of the complex?
Yes.
Okay. And they would have been staying right there the entire time, making sure who's coming and going, right?
Yes.
Okay. And then at this point, it sounds like the apartment was getting secured to search it, right?
Yes.
Okay. So does that mean putting up crime scene tape and everything?
I can't recall about the time of the interviews. They had crime scene up.
Okay. Some point it got crime scene tape, though.
Yes.
Okay. And when you say that the officers, deputies, whatever, were in the parking lot, were they just clumped up in one group together or across the entirety of the parking lot?
So some of the detectives were kind of in one group, and then uniform patrol were kind of in the perimeter for scene security.
And while State asked you if you ever removed your firearm. I just want to clarify. You had your firearm on you, right?
Yes.
And you're in plain clothes at this point, right?
Yes.
So is your firearm just chilling right there on your holster? Or?
Yep. On my hip, yep.
Yeah. So it's visible?
Yes.
And you said that while you're questioning, well, you and Detective Tagler were questioning Mr. Stearns, you're both standing by a vehicle, right?
Yes.
I don't know whose it is, but it was a vehicle, right?
Yes.
Okay. And at this point, Tagler's questioning him, you're questioning him, he's in the middle of you two, right?
I can't recall where he was between both of us.
Okay. But you're all towards, it sounds like the back of the vehicle?
Yes.
Okay. And you had stated that while Tagler's taking a look at the phone, you're close enough to see the phone, right?
Thanks,
Yes.
green-eyed
Okay, so you can
PI.
actually see what's happening on the screen?
Yes.
Okay. So it's not like when we're saying that you're standing around the vehicle, somebody's over by the front of the car over here and somebody's all the way at the trunk of the car over here. You're all grouped up together, right?
Correct.
Now, it was during that first interview that you learned that the phone was factory reset somehow, right?
Yes.
And
How do you defend the undefendable? How?
when y'all were leaving the scene, it sounds like Tagler gave you the phone?
She gave it to Mr. Stearns.
Okay. At the entirety of both first interview, second interview, everything. When you're taking the phone to the sheriff's.
Oh, sorry. Yes. Yes. Yes.
Gotcha. So you had the phone at this point?
Yes.
Before you had come into possession of the phone to take it back to the sheriff's office, it sounds like it was in Tagler's car?
I'm not sure where it was.
But between the first interview and the second interview with Mr. Stearns, it sounds like there's about maybe a 4-hour gap, right?
Yes, somewhere around there.
Somewhere around there. And at that point, you said that you went to the management to kind of take a look at the video surveillance, right?
Yes.
Okay. It'll take 4 hours to go through all the video surveillance?
Not all just at the video surveillance. We were also debriefing kind of next steps, things like that,
Right.
discussing the case.
So when you're saying debriefing, like, right, just you and Tagler, or are you talking other people?
Other people, the unit,
Okay, so where does that happen?
in the management area.
Okay. So at that point, while you're debriefing, roughly how many law enforcement personnel are there?
I don't recall the number.
Can you remember anybody that was there off the top of your head? Sure.
Detective Tagler, myself, direct supervisors, so maybe a corporal and a sergeant.
Okay. So at least 2 other people present?
Yes.
And it's at this point, so that's where you all were talking to supervisors, right?
Yes.
And at that point, it sounds like one of the supervisors was like, hey, we need to go get that cell phone, right?
Yeah, I believe it came up during the conversation.
Okay. And then during that conversation, did anybody ever mention, hey, let's get a warrant to download that?
Not to my recollection.
Okay. After you take the phone to the sheriff's office, do you ever interact with the phone again?
No.
Okay, so you just hand it off to the forensics guys and you're done?
Yes.
Okay. And did you ever ask Mr. Stearns if he could download the entirety of this phone?
I did. That conversation was had with Ms. Detective Tagler.
And did you ever seek a warrant to download the phone?
I did not.
Did you ever attempt to draft a warrant of anything?
I did not.
Your phone, Mr. Cooper? first interview and the second interview, you had neither you nor Tagler ever gave the phone back to Mr. Stearns, right?
Correct.
You held on to it the entire time.
Yes.
No further questions.
Did you conduct any interviews between the first and second interview with Mr. Stearns?
Yes.
Who else did you interview?
Jennifer Soto.
So that was also during that 4-hour period?
Yes.
No further questions.
Detective, between the first and second interview, around a 4-hour, at the conclusion of the first interview, did you observe anyone direct Mr. Stearns that he could not leave?
No.
And when you returned after 4 hours, Mr. Stearns was where?
He was in the same parking lot area.
Any follow-up questions, Steve?
No, yeah.
Follow-up questions, defense?
During that time span between the two interviews, did anybody tell him that he could leave?
I don't recall that.
Thanks. May the detective step down?
Yes, sir.
Is he excused from this appeal? Thank you, Detective.
Thank you.
Additional witnesses are up.
Yes, Your Honor. Sergeant Darko. Stamina?
Please raise your right hand for this morning.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Will you please say your first and last name and spell both for the record?
Darko Stamenic, Darko Stamenic.
How are you employed?
I'm currently a sergeant at the Orange County Sheriff's Office Digital Forensics Squad
How long have you been a member of the forensic squad?
since June of 2023.
What type of training have you undergone to perform some of your duties in the forensic team?
So going back to college at the University of Central Florida, I minored in IT. After that, I went to Cellbrite School, where I became a Cellbrite certified operator.
Here we go with
Cellbrite
Cellbrite.
certified physical analyst. Those are two certifications that we have to use some of the tools that we use. And then I also went to the International Association of Computer Investigative Specialists, where I obtained my certified computer forensic examiner certification as well.
Did you download any phones as part of the investigation into the disappearance of Madeline Soto?
Yes, I did.
Did you first download a phone that belonged to Madeline Soto?
Yes.
When did you begin that cell phone download?
It was shortly after 2 p.m. on February 27th.
Do you recall about what time that download was completed and viewable?
I believe around 5 o'clock in the afternoon.
That's a couple hours.
A couple hours, right?
Okay. So, can you explain
You're awesome.
how an extraction is done with the equipment that you used in this particular case?
Yes, so we have a tool that we use to extract the data. So we connect the phone to a tool. The tool's able to extract the data, bypass any whatever passwords there are on the phone, if there are any. Extract the data from the phone. Then we take that data, and we have another tool that parses that data, basically makes it readable by a human.
Is the time that it takes to extract the data from a phone variable upon the specific phone and maybe the data that's included in the phone?
Yes, absolutely.
Specifically, Madeline Soto's phone download, after it was completed, did you have the ability to share the data with other law enforcement officials that were working that same investigation?
Yes, I did.
How did you do that?
So we have a tool where we're able to upload that data that we extracted, and we're able to share it in the cloud to detectives, so detectives out in the field can view it.
Did you do that with Madeline Soto's cell phone the same day that
Yes.
you covered the data?
Yes, I did. I'm sorry.
Did you also complete the cell phone download for the defendant, Mr. Stern's phone in this case?
Yes, I did.
Do you recall when you received Mr. Stern's cell phone?
Yes, so shortly before 3 a.m. on February 28th.
Did you wait at Orange County Sheriff's Office Central Communications Building?
I did, yes.
So you waited for Detective Aosta to come from Kissimmee?
Correct.
What did you do upon receipt of the phone?
I began extracting the phone, and then I went home.
Sorry to interrupt. 2:28 at 3 a.m.
Yes.
So what specifically did you do with the phone to begin the extraction?
Connect it to a tool and follow the procedures on the tool to begin the extracting the data.
Was the cell phone itself secured in any way prior to your receipt of it to secure the data in the phone?
Yes, it was placed in airplane mode.
And after you plug the phone into the equipment that you utilized, you said you went home.
Correct.
Did the cell phone download process during your period of absence?
Yes.
Did you secure the room that this was being completed?
Yes.
And what time did you arrive back?
I believe it was about 8 a.m.
Did you check on the progress of the phone download when you arrived back?
Yes.
Was it completed?
It was.
Can you explain, for this particular phone, I believe it was a Samsung type phone?
Correct.
How do you factory reset it?
Yes, so you have to go into the settings of the phone. I believe the next button says general settings, so you have to go into there. Once you go into there, you have to scroll to a button that says factory reset. Once you press the factory reset button, it asks you a couple of times if you're sure. It makes you type in your PIN code to the phone again to verify that it's you to reset the password, to reset the phone, I'm sorry.
So it's multiple steps to actually accomplish a factory reset?
It is, yes.
Is this possible to do if you're simply updating the operating system on that particular phone?
No, the button to update is in a completely different part of the settings.
When this specific phone is factory reset and the user goes back on to, again, utilize the phone, is there any information that is populated on the phone from prior uses?
Yes, so when you're resetting the phone, it asks you to log back into your Google account, and then information that you have backed up on Google will repopulate onto the phone.
If the phone is placed in airplane mode, does that prohibit the phone from resyncing with a Google account?
Yes, it does.
If items are subsequently deleted from a Google account and the phone is in airplane mode, do the items remain on the phone if they've been backed up?
They do.
If a phone is factory reset, is it still possible to obtain location data and other information from before the factory reset?
It is, yes.
How do you do that?
Different ways. So, for example, the pictures, if pictures are backed up, if the pictures are pulled again, the pictures may have location data associated with them. So things of that sort.
It has no further questions.
Thank you. Cross-examination.
Good afternoon.
So you're in charge of doing the forensic downloads of the phone?
Correct.
Okay. And when you're doing those forensic downloads, you said that there's a tool that you plug the phone into to fully download the phone, right?
Correct.
So it's not just downloading the information that's immediately accessible to the user, it's downloading everything, right?
Correct.
When it's doing that download, does it do a bit-by-bit copy of the entirety of that drive?
No, it depends on the phone.
Okay. And with this particular phone, did it?
This particular phone, it did a full file system extraction, so it's not a bit-by-bit copy.
Gotcha. So when it does that, though, if the phone's factory reset, you can still pull that information off the phone, even though it's not immediately accessible to the user?
Like, I'm sorry, what information?
The information prior to the factory reset.
Oh, no, not necessarily, no.
Okay, not necessarily, but in this case, you were able to pull information prior to the factory reset, right?
Yes.
Okay.
Yes.
And when it comes to pulling that information, how long can that information stick around on the phone?
So in this case, the information had repopulated after the reset. So it was on the cloud, and then it repopulated on the phone automatically after the reset.
Okay. Do you know at what time it repopulated?
It was, I believe, around 2 a.m. After the reset. I believe the reset was around midnight, and over the next couple of hours, the phone repopulated.
When you're saying 2 a.m., same day that you downloaded it or before?
No, it would have been when the phone was reset, and I don't want to speculate the date.
Gotcha, no problem. When it comes to a phone being factory reset, are you on any kind of timeline to make sure to recover data?
Not really, no.
Okay, so that's not a concern to law enforcement, right?
No.
Okay, so once it's factory reset, it doesn't matter.
Right.
Of course. When you did the download of this phone, anybody give you a warrant alongside the phone?
No.
No, of course.
Redirect?
No.
Witness, step down.
Yes, sir.
Sergeant Stanek, excuse me.
Yes,
Sir.
Your Honor.
We're going to take a 5-minute recess. This court is in a 5-minute recess.
How long is this recess? How long did they say, guys? I get up for 5 minutes and they're on a recess. Sarah is going to plug her phone in and she's going to come in the chat and chat with us. Sarah is there at the courthouse today. Can I get a 5x5 in chat? I love that they're doing this to him because he wanted to get the cameras out. I love this for you, Stephan Stearns. I love this for you. I freaking love this for you. I want you to turn around and see that camera pointing right at your nasty ass. Taking advantage of that little girl. What is that, the judge's dental floss? Jay, I can't wait for you to see the carnage unfolding on YouTube. I heard. I hope you have your little Wii recorder going. Me too, Spectral. Me too.
Too fast? I know sometimes I can get on a roll.
A little bit.
Just making sure. Yeah, exactly.
Oh my God. Oh, girl. Not great. Next time I might give you like a little
Hot mics, gotta love it.
I wasn't prepared to expect you to stay there, like give me a call, give me a it's okay, you told me so and then she came back out and she didn't break. She just came in like you and she's like, go. No one. It's it. Hey, hey. What's everything I've been trying to do? Nothing's gone. Yeah, just hanging out. What are you made for?
She said he was getting cocky. She said he was starting to get cocky there in court. Hey guys, I walked out to charge my phone. Jay, thank God they didn't mess up. Holy moly. I know, Sarah. Tell us about the vibe in the courtroom. What's the vibe with Stephan? He's just plain nasty. I hope he gets heckled all day long. All day long. He's so gross. He's been working out, though. He's big. The vibe was tense. He was so scared. Then you saw him get... I know you don't mean kiss. Pissed, and his whole demeanor changed. Monster. Green-eyed. A parasitic twin. He is disgusting. Misty, I agree. I know, bless Gigi. Ugh, no, I can't imagine. He's a monster. I saw what Maddie saw. It gave me chills. Ugh, his eyes. I know, Kiwi. It's so sad. Sick. Listen, while we're on break.
Civil lawsuits. Somebody can sue you because they don't like the shirt you're wearing. And you're in a lawsuit. That's how easy it is. But the things that she's got going on in her...
Don't worry. It's being recorded. He was wearing orange Crocs. He was shackled and chained. Beat him. He's grasping the chain. He didn't... You got to get back in there, Sarah. That was a short break.
Whether we're going through all three motions today or just the first.
His list.
The state's position is that the burden is substantially different for the challenge to the warrant.
Understood. Do you believe that you have...
People watcher, you think he broadcast it?
For the first two motions?
The first two motions are the seizure motion and the consensual search motion, yes.
Thank you. Defense, in your motion as to the motion to suppress evidence obtained from the Google search warrant, there was some argument that the defense does not have the burden or has satisfied its burden. I'll entertain an argument as to that. Sure.
When it comes to the burden for attacking the warrant itself, the primary basis for the state's argument is...
How do you know that, people watcher? Did you watch it?
When it comes to the burden itself,
How do you know that?
we would be arguing that it's satisfied at least for the arguments we've heard at this point, considering not challenging the actual document itself.
Understood. So, did you anticipate presenting witnesses or evidence in support of that motion?
No.
Okay. So you were just going to present an argument?
Yes. Based on, right now we have the chain of how the warrant came about, and then getting to the cell phone download.
I thought there was no warrant.
Okay. So you're going to make argument as to the sufficiency of the warrant itself and technical defects?
Yes.
And rely on the evidence that's been adduced in cross-examination to support the probable cause, or the lack of probable cause for the...
Exactly.
Does that give the state any clarity?
No, Your Honor. Florida Rule of Criminal Procedure 3.190 subsection G3 specifically states if the court hears the motion on its merits, the defense shall present evidence supporting the defendant's position, and the state may offer rebuttal evidence. That the defense's burden is to show that there's grounds for suppression of the warrant. I don't believe that that burden has been met for the state to be required to present rebuttal evidence. The affidavit is not before Your Honor.
Understood. All right, so as to sufficiency of the warrant, what evidence does the court have to make some determinations as to the sufficiency of the warrant? Talking about the technical defects that are alleged in the motion.
Yes, Your Honor. At this point, it's actually part of the court file, so we could ask them not to take judicial notice of the search warrant.
It's not part of the court file. Search warrants are not part of the court file.
Absent some affirmative presentation of evidence regarding the argument, there is some kind of technical deficiency that makes the search warrant of the Google activity unlawful. It's going to be hard pressed to make a determination as to that. Let me ask the state. Are you requiring the defense to recall the witnesses that have just testified, or if they can find their argument to information that was elicited either in direct on cross, does that satisfy their burden, or shall we go through that entire exercise again?
I have a moment.
Sure.
Your Honor, the state is of the position that the defense's burden regarding challenging the search warrant has not been met. The state's not going to require the defense to recall the witnesses that have previously testified. However, there is no information before the court about the Google search warrant at this point. So the state's position is that they have not met their burden pursuant to the Florida Rules of Criminal Procedure to shift, to require the state to present rebuttal evidence at this point.
Additional testimony, the court's going to rely on the testimony that's been provided. There was a cross-examination and a redirect. That information is in the record. The defense can make argument that satisfies their burden or not. Is the state anticipating presenting additional evidence?
The state has an additional witness should the court find that the defense has met their burden to challenge the warrant.
Defense makes argument that the Google warrant relied on illegally obtained evidence and that there was no attenuation or intervening circumstances that first obtained. The court has heard testimony from the investigating detectives that challenges the legality of both the search and seizure. That appears to be what the challenge on the warrant refers to, and that it is invalid as fruit of those illegal searches. As far as the application failing to establish probable cause, the court does not have the application. As far as the legal standard, probable cause in digital search warrants, the court is uncertain what kind of warrant this was or whether it was a digital search warrant. The argument that it fails to establish the sufficient nexus between the Google account and criminal activity, I don't have the affidavit, so that would be a difficult finding for the court to make. The reliance on boilerplate language, again, we have no evidence to support that argument. The temporal scope of the court would have no evidence to support that.
People watching, you're sick.
Peculiarity for digital searches. Without additional information, the court would find that there's no evidence to support that argument. As to the evidence supporting the arguments that the search warrant is invalid based on lack of probable cause, based on reliance on illegally obtained evidence of intervening circumstances purging that taint, and being invalid as fruit of an illegal search and seizure. I think that evidence has been adduced in combination with the first two motions. So as to those issues, the court will find that there's been record evidence that supports that argument.
Given the hour at this point, the defense would be asking if we can buy for the first two motions and third, given the seven.
These three motions were set together, and we're going to address all three.
Good job, Judge.
Given the court's ruling, the state will call its next witness, Detective Taylor Heller.
Detective Taylor Heller is next to the stand. And just FYI, when we cover cases like this, don't come in here talking about pools of gunk next to a victim's bed. You will be blocked and never allowed back. You are disgusting for that. Shame on you. Shame on you. Yeah, he's blocked.
Please raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth to help you God? Yes.
Right this way.
Hi, Jenny.
Please say your first and last name for the record.
Taylor Heller.
Can you spell both?
Speak up, Taylor.
First name is Taylor.
Last name is Heller.
How are you employed?
With the Orange County Sheriff's Office as a deputy.
Were you employed with the Orange County Sheriff's Office on February 28th of 2024?
Yes.
Can I approach a witness with both the marked state C for identification?
Why does she look like she's falling asleep? What's going on here? Did you see her? She looks like she's falling asleep.
Can you take a look at state C? Did you draft the affidavit for search warrant encompassed in State C in relation to the Madeline Soto investigation?
Yes.
Is this State C a fair and accurate copy of that affidavit?
Yes.
Your Honor, at this time, the State C is introducing evidence with the marked State C into evidence is this.
Maybe she's sick.
No objection.
I know. What does she say? Stop.
Thank you.
Hold up. Put your hands in the air.
Cross-examination.
That's what I get for making fun of her.
Thank you.
Oh, she's done. Yeah, of course they still support him. They're enablers. They'll always support him. They're more worried about how he's going to get on without his favorite candy
This is our evidence defense.
than anything else.
Mayor, thank you.
I don't even know what that the fuck that was about.
Parties need a moment to gather their thoughts for arguments, or are we ready to go? Sure. Take a 5-minute
Oh my
recess.
God. Another break?
20 minutes to present their argument. I'll ask that you compartmentalize into the individual motions. Take a brief recess. Court is in a brief recess.
Bye, bitch. See you in 5, bitch. Hey, Pines. I understand. Good to see you, though. Yeah, like the little girl on Police Academy. Hold up. Thank you, Regina, for 9 months of membership. I'm late. What did I miss? Also, Jay, you look pretty today. Blessings and thank you for all you do in the true crime community. Much love. Nice to see you, Regina. You haven't missed a whole lot. They're just arguing about... They don't want the cell phone evidence brought in. So they were like going about how he gave consent, how they didn't have a warrant, etc., etc. What'd you get, Kels? Katy Perry cancels concerts last minute amid space fight backlash. In the wake of the widespread backlash for her participation in the Blue Origin space flight, Katy Perry announced the cancellation of 2 of her tour dates. She said the arena won't be ready in time. So she went up in space to talk about her concerts and then cancels them. Ew, he's refusing to take showers. A 2-day concert, 2 days in a row. Her and her little daisy in space. Get out of here. Did you guys see Joe Rogan talking about it? Joe Rogan roasted it. Oh, she's the one that drafted the search warrant? Thank you, Tabby, for rewinding. I didn't have it in me. Audio tapes from Harmony Montgomery's custody hearings? Oh, wow, that's huge, Spectral. Oh, that's going to anger a lot of people. Wow. Thanks for letting us know. We follow that one, too. Julia, the dog handler? Thank you, Nash.
Please come to order.
Here we go. Here comes the monster. Poopy butt.
This time, defense is moving to suppress the evidence obtained by way of the Google extraction and the entirety of the data that was elicited from Google that was sought by a warrant. Defense is also seeking to suppress the actual cell phone itself and the data contained therein. For the first two arguments as to the unlawful search and seizure of the cell phone, defendant is relying on the United States Constitution, Fourth Amendment, as well as the Florida Constitution, Article 1, Section 12, specifically that as we go through this is all kind of intermixed between the three motions. But looking to the first motion as to the seizure of the cell phone, at this point, now that the burden has shifted, the state bears the burden to prove an exception to the warrant requirement in order to seize the personal property of Stephan Stearns. As to the seizure, defense would argue that no consent was either sought nor given for the seizure of the cell phone, as well as the fact that there is no exigent circumstances that would create this being a constitutional seizure. As to Detective Tagler, the exact evidence that was elicited was that the detective had informed Mr. Stearns unilaterally that she was going to hold on to a cell phone. This was a declarative statement, not a request, and there was no opportunity to refuse the turning over of the cell phone at that point. Detective Tagler had the cell phone in hand, was clearly exercising dominion and control over the cell phone, and told the defendant straight up that it didn't matter that he wanted to get in touch with his parents or to continue getting in touch with his parents as the night went on, and simply dismissed Mr. Stearns' concerns and unilaterally seized the phone. The seizure of the phone itself occurred at approximately 8 o'clock at night. I believe it was 19:59 hours on February 27th. And as of the morning of February 28th, the phone was still in law enforcement's possession. As it was taken to digital forensics at the the Orange County Sheriff's Office, the phone was still in law enforcement possession, which we start getting to a point where we're looking at several hours worth of seizure. The state, or the defense, in its motion to suppress based on the unlawful seizure of the cell phone, had cited to United States v. Place, where the seizure of personal property in that case was found to be unreasonable for a time span when this personal property was held for 90 minutes. We're well beyond 90 minutes at this point.
Thanks for being here,
and there was no attempt to minimize the intrusion of the seizure of the cell phone. Looking to the state's response, I understand that the state is going to be arguing exigent circumstances, but there was critical testimony elicited from the digital forensics examination witness who stated that once a factory reset occurred, to law enforcement, there was no hope of getting anything after that. During the first interview before the cell phone was seized, law enforcement knew that the cell phone had been factory reset. They dug through his cell phone and they confirmed that it was factory reset. At that point, no exigent circumstance existed as to imminent destruction of evidence, because at this point, essentially, Your Honor, it was destroyed in law enforcement's eyes. The gentleman testified the fact that there's no time span or immediacy when it comes to learning that the evidence could have potentially been destroyed when it comes to a factory reset. Additionally, the timeline itself of law enforcement's involvement in this case entirely negates the urgency element for the imminent destruction of evidence. From the time that the missing report came in to the time of the seizure of the cell phone itself, it was approximately 20 hours had elapsed. There was no immediate action taken to collect this cell phone, and this lack of immediacy completely contradicts the claimed imminent threat by the state. Additionally, when it comes to the seizure of the phone, there was no warrant ever sought. There's no warrant that was presented. This was, again, unilateral action, even though there's been an emergency judge ready to go on duty since the 80s in the 9th Judicial Circuit, both for Orange and Osceola counties, for law enforcement to seek a warrant, and yet they chose not to. When it comes to any other potential claimed exceptions, such as the emergency aid exception, it was clear from the detectives that looking through the phone, the seizure of the phone, this was in order to further investigatory purposes. This was not a situation where they were seeking to render any emergency aid. The community caretaking exception to the warrant requirement absolutely doesn't come into play. The phone posed no danger. There was no community protection purpose. This was purely an investigative seizure. As to the attenuation for this warrant, or for the seizure, there is no attenuation from the moment that Detective Tagler took possession of that phone, handed it off to Detective Aosta, and then handed it off to the Osceola, or the Orange County Sheriff's Office. I apologize. There were no intervening circumstances.
This is terrible.
This was one continuous chain of possession by law enforcement. So, essentially, the seizure, Your Honor, there's no warrant that's been sought. There's no exigent circumstance
she had permission,
that allows law enforcement to collect this beyond the mere claim that they could just unilaterally take it. So for the seizure itself, we would argue that that's for.
Thank you. State, would you like to reply on a motion by motion basis? That'd be helpful.
In the meantime, I know the defense cited some of the case law from their motion. I did have the opportunity to review most of the case law. There is one case that I had difficulty finding, so if the defense has a correct site or a copy of the case, I would appreciate it. I could not find Appellate v. State, the site that you cite. I could not locate. It's on page 7 of your seizure motion. As far as the defense's argument, the defense relies on place, and place is actually distinguishable. Your Honor, I did provide a court exhibit A. I also have a flash drive. I prepared all of the state's case law from the motion, and I put it on USB, organized by motion, so that it was easier to be accessible rather than providing a bunch of paper copies. The state's relying on all the case law presented in the motion, and I made it a court exhibit so that it's in the record for appellate purposes. The first thing that we need to do, Your Honor, is decide whether or not, or what type of seizure this was. I would agree with defense that this was a warrantless seizure of the defendant's cell phone. A warrantless seizure of the defendant's cell phone is permissible when you have probable cause plus a warrant exception. In this case, the state's relying on exigent circumstances. The probable cause, there's numerous case law that defines probable cause. The court's well aware of the case law defining probable cause and what it is. Exigent circumstances, there's also a lot of case law regarding exigent circumstances. The specific cases that the state is relying on are U.S. v. Babcock, State v. Darter. The state has to show for exigent circumstances. The test that's used is an objective one. The factual inquiry is the totality of the circumstances. The exigent circumstance that the state is relying on in this particular case is the destruction of the evidence. Courts have found this exception particularly compelling when you're dealing with digital evidence, and that can be found in the Babcock case. We have detectives who are on scene with the defendant, and at the time that the defendant's cell phone is seized, which is approximately 8 p.m., they had the opportunity to view some of the items in his cell phone. They also knew that Madeline Soto did not report to school. Madeline Soto has been missing for over 24 hours. The defendant was the last individual to have seen Madeline Soto alive or seen her in person. The defendant attempted to destroy evidence already by factory resetting his phone. He did this on the same day as Madeline's disappearance. That's evidenced by the history that is in his phone that he consented to looking at. The sergeant from the forensics unit testified what it takes to go ahead and factory reset the phone, but he also indicated that when a phone logs into the Google account and the backup starts repopulating, which is what happened in this case, that content will stay on the phone as long as the phone is not syncing with the Google Cloud account. There's evidence and testimony that upon the seizure of the phone, law enforcement officers place the phone in airplane mode to prevent that syncing. Should the defendant have accessed his Google account and removed multiple items from the Google account, it would not have removed it from that particular cell phone, because that cell phone was in airplane mode and was no longer syncing with the Google account.
How did it sync? How did it repopulate it? Stop syncing.
When the phone was factory reset and that information corresponding with that Google Cloud account was input upon the starting up of the phone, everything that was backed up on the Google account from that phone began
Sharon.
populating on the phone. And that's the 2 a.m. population that Sergeant Stamanik mentioned that occurred the early morning hours of February 27th. So prior to these interviews, all of those photos and everything else began to populate on that phone that was in his backup. So when law enforcement saw that there were various items missing and the defendant had already tried to destroy the evidence, it was at that point that they seized the phone, placed it in airplane mode to prevent further destruction of evidence. There was also testimony that even though the defendant factory reset the phone, there was still a possibility through different avenues to ascertain that cell phone's location information and different things. So at that point in time, there was a fear that was objectively reasonable to a reasonable law enforcement officer that would lead that officer to believe that the evidence might be destroyed before a warrant could be secured. That is the standard. Probable cause plus exigency. Everything that was known to these law enforcement officers prior to this seizure supports the probable cause finding as well as the exigency finding. They also were aware that the defendant was inconsistent in his statements to law enforcement about where his whereabouts were on February 26th, the day that Madeline Soto went missing, because his initial statements were contradicted by the actual tag reader for his vehicle. His vehicle was seen traveling in the opposite direction of Madeline Soto's school when he indicated that he was driving towards the school and going to McDonald's and dropping her off. There were other inconsistencies that are within those statements that he made, specifically the ones that were provided to the court and are entered into exhibits in this particular hearing. There are multiple inconsistencies. All of these things lead to probable cause and exigent circumstances for the seizure of that phone. Therefore, the seizure was permitted by the Fourth Amendment in this case, regardless of whether the defendant said, yeah, go ahead and take my phone. The law enforcement officers had the ability to do that. The defense also mentioned place. That case is distinguishable because in that initial detention, that 90-minute detention that they're talking about in there was based upon reasonable suspicion alone. That court then later says that once that dog sniff was done on the luggage and they developed probable cause, that's where they get the 90 minutes from the time that the luggage is detained until they've secured probable cause. That's not the standard here because the state's relying on the probable cause plus the exigency to support the seizure. So the place case is actually inapplicable to this case as far as the defense's attempt to have the reasoning support their argument.
Thank you. Brief rebuttal, and then let's move on.
Briefly, while the state argues that there's the two-prong analysis as to probable cause and the exigency, Again, when it comes to the exigency, the direct testimony that was listed during the hearing is that to law enforcement, there is no exigency at the point that this phone is known to have been factory reset, that there is no imminent destruction of evidence because there's no further destruction of evidence. It's already been destroyed. So while we can speculate and guess as to what Tagler and Aosta, the detectives on
why
scene,
would they
were thinking
destroy
as
it?
to seizing the phone, what we know for a fact from the Orange County Sheriff's Office is that they know that once a phone's factory reset, it's gone. There's no more imminent destruction. So for the exigency element, I would argue that makes sense. Moving on to the second motion, if Your Honor's ready.
Mr. Johnson, I'm ready.
Yes, sir. As to the motion to suppress the unlawful search of the cell phone, again, the burden is flipped to the state. They have the burden of proof to show some kind of exception to the warrant to search of this phone. There was no warrant ever obtained for the actual search of the phone, be it the searches done by Detective Tagler on scene, nor the actual cell phone forensic download. Now, as to the first request by Detective Tagler on scene as to the maps, the statements from Detective Tagler was, "Do you mind if I look at your maps real quick?" At that point, the defendant, Mr. Stearns, had indicated, "Yeah, that's fine." When we look to consent, scope of consent is an essential element when looking to the validity of law enforcement's actions. At this point, there was limited consent to look only to the maps application only, not consent to search the entire phone. As to the second request, as to when Detective Tagler asked, "Do you mind if I just take a picture of your history?" and Mr. Stearns replied, "Yeah, that's fine." Again, this was limited only to taking a photograph of what was already visible on screen, not consent to navigate through the rest of the phone, through additional screens, not consent to access other applications. To the third request from Detective Tagler, if I can go into your settings real quick. I just want to see if you're logged onto your Google. Again, at this point, after pressing Mr. Stearns agrees, but again, this is, limited consent as to merely looking at the settings screen to determine if he's logged into Google. At no point did any of the detectives or any member of law enforcement seek consent from Mr. Stearns to go through the rest of his cell phone, which then we can see Detective Tagler's overstepping the scope of consent when she later indicates, "I was checking your call history. I noticed that you don't have anything before this morning." But when questioned, and as evidenced in the recordings that Your Honor has, there was never any consent sought or given as to checking the search of the call history in this case. So that is completely outside the scope of the searching of the maps, the history photo, or the Google login check. Additionally, when we're looking to consent as to Detective Tagler's request to do an entire forensic download of the phone, this is where defense relies on the Ramirez factors. When looking to the Ramirez factors, the defense looks to Mr. Stearns' freedom to leave. While the state is going to argue that he was free to leave, and the detectives stated that he was free to leave, no statement was ever made to Mr. Stearns that he was able to leave the scene at any time. Instead, what happened is that...
Is that required, or is that a factor to be considered?
It's a factor to be considered. And when considering that factor, we're also looking to what a reasonable person would feel in that situation. So at this point, Mr. Stearns is being corralled by two detectives by a vehicle. He's not allowed to go back inside of his home. He's not allowed to go inside of his own car. When it comes to the apartment complex, there's law enforcement all around. There's law enforcement at the entrance regulating who's coming and going outside of the apartment complex. It's clear that law enforcement essentially has the scene locked down. And not only do they have the scene locked down, while the state asked whether anybody had drawn firearms or anything of that nature, it was clear from everybody that testified that firearms were readily apparent, visible on scene, which would lead to Mr. Stearns feeling that he was not free to leave. When we're looking to any potential coercive police procedures, again, we have a situation where Detective Tagler systematically keeps pushing boundaries of searching Mr. Stearns' phone. First, it's just a check for, hey, can I check the application? Then I want to take a picture of the phone. Then we're going to keep pushing into the settings. And then the detectives push more and more to the point where they start checking other parts of his phone without asking him for his consent. So at this point, a reasonable person would believe that, well, law enforcement has my phone in their possession. Law enforcement's going to keep looking through the phone. And while the argument is that he stood there and never said no, it's not the onus. The onus is not on Mr. Stearns to say no. The onus is on law enforcement to ask if they can continue to go through this, because the scope of consent is limited. And while the detectives and the state want to argue that, well, he stood right there and never said no, Your Honor, some 200 years ago, our forefathers said no for him. That said that we have a situation where there's no warrant. Law enforcement has seized his phone. They're searching his phone. The Fourth Amendment says that you cannot do that. The no has already been said for him. When we're looking to the ability to refuse consent, additionally, law enforcement never told him that he could refuse to allow them to look through his phone. As to the education and intelligence, when it comes to law enforcement's testimony, they knew that Mr. Stearns was currently in a state of, or this actually goes more towards physical and mental state, that Mr. Stearns was currently in a distraught, stressed out state. They were aware that he was taking medication to try and fall asleep, to take care of himself during these long hours during the course of this investigation. When we're looking to the actual physical state of Mr. Stearns, we know it's about 50 to 60 degrees outside. We know it's night. We know the sun has gone down. We know law enforcement's with him. We know that he's in flip-flops and khaki pants, and he's not allowed to go back inside his house nor his car. So physical discomfort may have affected his decision-making process.
Physical discomfort? Get the fuck out of here.
It's not what law enforcement believes that Mr. Stearns was. It's what would the typical reasonable person have understood what the situation was. And in this case, Your Honor, the defense would argue that as Detective Tagler consistently pushed the bounds, then held onto his phone, just unilaterally seizing it, dismissing his concerns about trying to contact his family, comes back hours later and gives him the Hobson's choice, that ultimatum of, you can either consent or we can get a warrant. At that point, Mr.
That's the way it goes.
Stearns' ability to consent has been tainted, it's been coerced, and for that reason we would argue that all of the searches of the phone...
Sit down, sir.
Thank you.
Sit down, bitch, sit down.
Ready?
Your Honor, the defense is not arguing that the defendant did not consent to law enforcement looking at his phone. Some of the things that I think are important to point out to the court is that the defendant in this case was free to leave. Both law enforcement officers that were interacting with him were in an open parking lot where he was free to move about. He was in and out of Ms. Soto's vehicle. There was no testimony before, Your Honor, that there was any threats or prohibiting of his movements. The defense argued that Detective Tagler consistently pushed the boundaries. However, Detective Tagler did not push the boundaries of consent in this case. There were multiple things where she was verifying with the defendant his continued consent for her to examine different parts of the phone. The defendant was in possession of his cell phone, unlocked it, and provided it to Detective Tagler. The defendant did not try and retain control over the phone. The defendant did not try and take the phone back from Detective Tagler. The defendant did not try to himself show her various portions of the phone. There was no attempt by the defendant to limit the consent in any way. The scope of the consent is measured by objective reasonableness. What would a reasonable person have understood to be the object of the search during the exchange between that person and law enforcement? You have Detective Tagler, after speaking with the defendant and him being inconsistent about timings and locations, she asks him, do you mind if I look at your maps real quick? The defendant confirms. It's at this point he unlocks his phone and hands it to Detective Tagler. Detective Tagler does not walk away with the defendant's phone. They are standing shoulder to shoulder. The defendant can see everything that Detective Tagler's doing. Detective Tagler then says, do you mind if I just take a picture of your history? To which the defendant responds, that's fine. There is no attempt to limit the type of history that Detective Tagler is going to look into. There is...
Spit it out.
This conversation happens. The detective is looking at the
Hi,
defendant's
One-Eyed
phone.
Flo.
Subsequently, the
I missed you.
detective looks at the defendant's call history. And there's actually a conversation with the defendant about how Detective Tagler doesn't know how to use the defendant's specific phone. She also asked to go in the settings, and in the audio recording, there is actually a substantial pause before she's finds where the settings are.
Why isn't this on body camera? Oh, because they're detectives.
She actually says,
That's
I don't
right.
know how to use this phone.
Never mind.
Sorry, I didn't mean to interrupt, as he's having a conversation with Detective Aosta as well. There is no time during that encounter that the defendant attempts to withdraw his consent or limit his consent in any way. The defendant does receive the cell phone back from Detective Tagler. There is a portion in the interview where she does say, here you go, to which the defendant responds, thanks. It's a little bit further away from the microphone, so it's a little bit harder to hear, but that conversation does take place before she asks the defendant a second time to unlock the phone. So the defendant does regain possession of the phone. Then she asks to unlock the phone a second time after she steps away. The defendant does so. Again, does not limit the consent in any way. There's actually no conversation at that point about what is going to be looked at. And then she brings up the fact that his call history is not there.
Is this information that she had prior to giving the phone back? Correct?
She says, I was checking your call history. I am unclear at what point she looked at it. I believe it's around this encounter, but it could have been before. My position, the state's position, is it's during this time frame where she's asking.
The argument
Thank you,
of the
Amanda.
state was that she asked to take a picture of the history, looks at the call history.
She takes a because it's what a reasonable person would understand the interaction is going to be. My position is that she uses general term history, and then she eventually goes into the call history.
Is that in the first time she's got possession?
That's in the first time that she has possession of the phone. Yes.
At what point in that sequence is the exigency argument, is the state's position that the detective becomes aware of an exigency of the destruction?
It's the second time he hands her the phone, because she asks him to unlock the phone. They have a conversation. She brings up that the call log, she said, I also noticed, I was checking your call history, I noticed that you didn't have anything before this morning. Is that unusual on your phone?
And that's when the discussion about the
Factory
reset occurs.
Yes.
It's the state's position that on that discussion, that provides the basis for the state's exigency circumstance.
Yes, coupled with everything else that law enforcement knew, yes.
Probable cause.
Yes, yes.
Sorry, I didn't mean to misdirect you.
So it's at that point that there's a seizure. There's some other information that's ascertained by law enforcement, and then they do a second interview with Mr. Stearns. The second interview begins at 12:16 a.m. and almost immediately jumps into addressing consent to forensically download the phone. It's not very long after their initial introductions on the audio recording. She says, I told you I was going to hold on to the phone.
Hey, Tato.
We would like to download your phone. Is this something that I have your consent to do, or do I need to get a search warrant for your phone? The state's position is the way that that statement is phrased, it is clear to a reasonable person that the defendant had the opportunity to refuse to consent, because either the defendant can consent. If the defendant does not consent, law enforcement ultimately would seek a search warrant. The defense wants to call that an ultimatum. The state's position is that it is advising the defendant very clearly that he has the ability to object or not allow consent for the forensic download. There's no question that law enforcement was seeking a complete download and to go through the entirety of the phone by the way that that conversation is had. Because he ultimately answers that question affirmatively, and then she follows up, you're okay with us going through your phone? To which the defendant responds yes, and then he ultimately provides his passcode to the cell phone. Based upon all of the totality of the circumstances and all of the information that law enforcement had, and the lack of coercion by law enforcement towards it. In fact, the defendant was actually free to leave and did leave the apartment complex after this second interview. He wasn't allowed to leave in his vehicle because his vehicle was seized, but he and Jennifer Soto left in Jennifer Soto's vehicle. That goes to any coercive nature argued by the defense. The state also relies on the same factors as permitted by case law. Whether or not the defendant was free to leave, whether there was any coercive police procedure, the extent of the defendant's cooperation or his awareness of the right to refuse, whether the defendant could have refused, defendant's education and intelligence, and the defendant's...
I think as fast as I type, so let's, I was with you up to extent of cooperation.
Or his awareness of his right to refuse, whether the defendant could have refused consent, the defendant's education and intelligence, and the defendant's belief that no incriminating evidence would be found. All of these factors should be considered by the court in determining the defendant's voluntariness of consent. So the state has to show that the consent was voluntary by clear and convincing evidence, and the consent has to be freely and voluntarily given. That is the standard. There was some case law that distinguishes it from a formal waiver of Miranda and things like that, other constitutional rights. The standard for consent is whether it was freely and voluntarily. So these factors that we just discussed go to the voluntariness of consent. So for the consent that occurs on February 27th, so that first interview where they're actually looking through the phone, the state's position is that consent was valid. The defendant unlocked his phone twice and handed it to Detective Tagler twice. The defendant specifically
The defendant is wasting our time.
To map data viewing and documenting his history, reviewing settings to see if he's logged into his Google account. The defendant was standing directly next to Detective Tagler as she was viewing the content. There was not the word history was used in the state's position in a general way. It wasn't a limiting way. And at no point did the defendant intend or verbally or physically or any other way communicate that he was limiting or withdrawing consent. He was free to leave during the conversation. He was not in handcuffs. There was no police coercive tactics. The state's position is the defendant was aware, based upon the questioning, that he had the right to refuse. He could have not unlocked his cell phone. He could have said no. There was a lot of testimony that he was free to leave and he could not have consented. They're not in a confined space. And the biggest one is the defendant thought he destroyed all of the evidence. The defendant factory reset his phone twice on the date of Madeline Soto's disappearance. And the reason why he consented is he believed that everything was gone. So the state's position is that the consensual searches that were conducted in this case were valid and permissible under the Fourth Amendment.
Thank you. Brief rebuttal. As to the state's argument that looking to Mr. Stearns' belief that he was free to leave, again, this isn't on law enforcement's observations. It's based on what a reasonable person would believe in that situation. Here, while we don't have
We'll be right back.
What happened?
I'm just sick.
What happened? I get up to get my Aldi order. What in the pure world is going on? What? Hold on. These stations are whack, dude. Fox left too? They lost their feed.
Check.
They lost their damn feed. Yeah, all of them. It's a pool camera. Oh my God. Hi everyone. Our camera is down briefly, but will return shortly. I know I went to go grab my Aldi order. There's always some kind of issue. Let's see if Sarah is texting. They have no audio either, so they must be working on fixing it. Fox 35. No, they'll probably keep going. They probably don't even know the camera stopped.
You're watching Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. I'm Garrett Weimer, and thanks for joining us on this Wednesday afternoon.
What happened,
I want
Garrett?
to show you some video from Palm Bay where two brush fires broke out this afternoon.
Kidding me? Brush fires? We're back. Oh no, this is a replay. Yeah, now they're talking about brush fires. All of them. Wow. They just ditched it. Yeah, it still says, look at it. It says closing arguments in Stephan Stern's hearing, and it's these fires.
And then it came close to the canal and started jumping the canal, which put all the homes behind us here in danger. So the other fire that came in almost simultaneously to this one was actually called in by one of the units that was responding to this fire. So it didn't
I
come
mean,
in
really?
with a 911 call. So, you know,
What the fuck? Is that not weird? Yeah, still these fires. Are these people behind or? I'm so confused right now. Sarah. Court's in recess while the judge makes a decision. Okay. Thank you. Because there is no live feed for this right now. I don't know if they're even going to bring it back because they moved on to the fires. Unless they're going to cut into the fires.
because we just simply couldn't get to it.
And the other one, y'all are investigating maybe a homeless camp situation.
That is what I'm told. I can't confirm that, but we have had repeated fires in that area over the last 2 or 3 days. And with the conditions being as dry as they are, it's impossible to be okay with the
I
use of
think
open
it'll
flame and, discarded, incendiary sources, because it literally takes nothing for a fire, especially in these conditions, to grow and get out of control.
And last question, what is your message to viewers to take this weather seriously?
WKMG, let's see. Yeah, they're live with these fires as well. I don't understand it.
Trim back your lot lines, make sure everything stays nice and tidy, clear the debris from your homes. And again, if you see something, call it in. Let us decide whether or not it's been
This
handled.
isn't even
if we know about it
newsworthy.
yet.
Like,
more than likely we'll have.
there's not even fires. It's all smoke. Like, this seems weird to me. I don't like it. I don't like it. I mean, how long is the break? And usually they just stay in the courtroom.
News at 5, which is beginning. We know Fox 35's Esther Bauer is out on this scene. She'll have updates on it and more details. I know she's been speaking to folks.
People are
in
like,
that
what happened
area
to what
that
we
have
were
been,
watching?
Evacuated and affected by this, continuing to watch that situation. So we'll have new details on that coming up in just a couple of minutes here on Fox 35 News at 5. Fox 35's Randy Hildreth has been inside the courtroom all afternoon for the Stephan Stearns suppression hearing. She's going to get us caught up on all of that, including what we heard from Stephan Stearns earlier today, testifying about not giving consent for the search and seizure of his cell phone, something that was discussed, as well as the lack of a warrant. So we are continuing to monitor that hearing, as well as our time here on Fox 35 News Plus comes to an end. So it's been a busy day. We know there's still a lot to come, and so we appreciate you joining us here. We will go ahead and send things out to Studio A, where John and Luann are getting ready for this.
Well, you're in Studio J right now, and I don't know if we're going to be back with this hearing, guys. It's all brush fires. I mean, we don't even know if there's a break because they just left what we were watching. Yeah, she hasn't responded, so she's probably still listening. Oh, tap us in, yeah. I mean, like, is the judge going to put his decision in writing, or? Yeah, the camera's cut in the courtroom, guys. Cameras were cut in the courtroom. We'll wait a few minutes, see what happens. I'm going to order my dinner. I'm starving. I'm getting hangry. Right, sometimes they take their time to decide and put it in writing. I think I'm going to order a pizza. They said they had a problem with the cameras. It doesn't look like they're coming back. Sorry to yawn. It's been a day. It's been a day. You're doing pizza and garlic cheese? What's garlic cheese bread? That sounds good. Oh, Lavender, you live too far. I'll refresh it again. I'm sorry, guys. I don't know what happened with that, but when I hear about the decision, I'll post it in the community tab. All right, guys, I'm going to go ahead and end this out. I will post the update in the community tab when I hear it. I know it's not my fault, but it's like, what an ending, right? Petered out. Yeah, I tripped over the live feed cord. Oh! Thank you, guys. Thank you, moderators. I'll see you lovelies in Discord. Let's run our credits because we did get some new clickers today. But hopefully the judge rules that it stays in. I'll let you guys know ASAP. All right, you guys have a great day. Enjoy your evening. I'll see you in the next one. Thank you so much for watching. If you enjoyed this live stream or video, make sure to give it a thumbs up and hit that subscribe button so you don't miss out on my latest content. Want to take it a step further?
Bring it all in.
And join our community clickers by becoming a Patreon or a YouTube member. You'll get exclusive access to our Discord server, special channel perks, and much more. Until then, I'll see you in the next one.
Click. It's real easy, man.